All right, so again, good morning to everybody. I'm Judge Wolf. It's 9:01, so I'd like to get started. This is a criminal warrant application calendar. It's Monday, July 15th, 2024. We're in courtroom 2C at 9 o'clock. I know that there are a lot of people who are going to make it here who aren't quite here yet, but for those of you here, when you hear your name, please stand just briefly, if you're physically able to, just so I know that you're here. And then I'm going to have a brief announcement after that. So let's go ahead and call the calendar first. Number 1, 24 MAGC 02241, Robert Barampur.
Good morning, Your Honor. And if I could make an announcement for 11 of the people on your calendar.
Okay.
There are 11 warrants. Actually, there are 16 warrants, 11 of which I represent the respondents, and I am here on their behalf. I can give you those warrant numbers if it's easier to check off now.
Your Honor.
I got through, excuse me.
Hold on, I can only talk to one of you all at a time. I promise you'll get to say what you need to say. Right now, I'm just checking folks in. So I'll start with you, Mr. Brickman. What are the connected cases?
All right, so 24 02241, the respondent is Mr. Barampur.
Okay.
02242, the respondent is Christian Kitchell.
Hold on just one moment.
Sure, no problems.
Number 8. Okay, that's number 8. Go ahead.
02244. It's actually, that's a thong win, but it's thong.
Let me find 44. That's 10.
02245, Meredith Verdone.
4, 5. That's number 14.
02246, Brian Moynihan.
Do you see that one?
That's number 9, Ron.
Number 9. Thanks.
02250, Jared Kagan.
That's number 6, Ron.
Number 6.
02256, Jim Pastor.
It's number 11.
Okay.
02257, John Walsh.
15. Thank you.
02258, Mary Suter.
You said 13?
Yes.
Thank you. Anybody else?
Yes, sir. 02259, Jeremy Feigelson.
It's number 5.
Number 5.
And one more.
Thank you.
02260, David Bernstein.
Number 3.
Number 3. Okay, give me just a moment. So that is okay, by my count, that was position 1, 3, 5, 6, 8, 9, 10, 11, 13, 14, and 15. That's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 cases, 11 applications, maybe more warrant applications. Is that what you said?
I did.
You think so? Okay. So please have a seat. And sir, are you on one of those cases or some of those cases?
Yes, sir. I am the petitioner, and I do not see any of the respondents here, and it's required for them to be here. And just like I came here, it was the order was it's mandatory attendance.
I understand. Again, what I'm doing at this early moment is
Yes,
just
sir.
checking folks in. So you're Mr. Underwood, correct?
Yes, sir.
Okay.
And lastly, Your Honor, I just filed a memorandum in the clerk's office, so I don't know if you had a chance to get to it yet.
I'll take a look at that as
Okay.
well. Thank you. Okay, so let me do this. I do want to call the entire calendar. We do have a few more people in the courtroom now as well. By the way, if you look around the courtroom and you don't see the other side of a case, I'm gonna give the other side of every case till about 9:30 to get here. It's not the easiest place to get to, particularly on a Monday morning. So just please understand, if the other side isn't here and they got good notice to be here, I'm gonna give them till 9:30, but not much past that. So let me go ahead through these cases. Position 1, 2241, Mr. Brickman for the respondent, and Mr. Underwood is present.
Your Honor, if I
Yes.
may. My name is Jennifer Burbine. I'm co-counsel with Mr. Brickman. I'm from the Warrants.
Okay, thank you. And so then we've got position 2, case ending in 2251. Mr. Underwood is here. Is Nicholas Beezer or Bizer?
Good morning, Your Honor. Danielle Lejeune. I'm here on behalf of Mr. Weiser in this case, as well as we have 5 that actually fall under me and my co-counsel, Mr. Jeffrey Monheit.
Good morning, Your Honor.
Good morning. And so y'all can have a seat. I'll tell you what, at this point, just when those other cases pop up, just let me know. Thank you. Okay, so both sides are here on number 2. Number 3, case ending in 2260, Mr. Underwood is here. And is David Bernstein or Bernstein?
Your Honor, of the 11 cases that I.
Oh, I'm sorry. That is one of your cases.
Yes, sir.
Got it. Thank you. Number 4, case ending in 2253, Mr. Underwood again. I don't think this was one of the cases we've talked about. Aman Bhutani.
That's one of mine.
Got it. Okay. And one moment. Sorry, I have to make one more minute here. Okay, number 5, case ending in 2259, Mr. Underwood. And this is Jeremy Feigelson. This was one of Mr. Brickman's cases. Both sides are here. 6, case ending in 2250, Jared Kagan and Eric Underwood. And so your client's here on that one too.
And my announcement, I represent each of those 11. None of those respondents are here.
Got it.
On their behalf, but the 11
Okay.
cases that we decided. Yes,
Got it. But you're here on their behalf.
yes, sir.
Thank you. Okay, and then 6, 2250, Jared Kagan, same category. Mr. Underwood is here. Then number 7, ending in 2254, Nima or Nima Kelly. Okay, y'all are here on that. Mr. Underwood is present. Number 8, ending in 2242, Christian Kitchell. Same announcement from Mr. Brickman, I believe, and Mr. Underwood is present. Number 9, ending in 2246, Brian Moynihan, and Mr. Underwood is here. Mr. Brickman for Mr. Moynihan. Number 10, ending in 2244, Mr. Brickman for Mr. Nguyen, Mr. Nguyen, and Mr. Underwood is present.
I don't represent Mr. Nguyen.
I'm sorry?
Nguyen? Don Nguyen?
Yes,
Yes.
yes. Did I say that right?
Murder.
Okay.
Is that case?
Thank you. Number 11, ending in 2256, that's Mr. Underwood, who's here, and Jim Pastore.
Yes.
That's another one with Mr. Brickman. 12, ending in 2255, that's Mr. Underwood again, who's present, and Justin Redmond. One of y'all's, thank you. Number 13, ending in 2258, Mr. Underwood. And we've got Mary Suter, that's with Mr. Brickman, I believe. Yes. Number 14, ending in 2245, Mr. Underwood is present, and Meredith Verdone is also one of Mr. Brickman's clients, as is on 15, case ending in 2257, John Walsh. And then Mr. Underwood is present. And then lastly, we've got position 16, 2252, Keena Willis. And that is y'all's case as well. Thank you. And Mr. Underwood, of course, is present. So that does complete the calendar call. Are we missing anybody? Is there anybody who thought you would hear your name called, thought your client's name would be called, and they weren't? Okay, so I do think that that completes the calendar call. It's a little bit unusual for this kind of calendar, but that's fine. Usually we have a bunch of unrelated cases on. It looks like there's some common thread to all these cases, same applicant, I believe, on all of them. So let me talk for a minute, even though I'm usually talking, like I say, to several parties who maybe have, or in different circumstances. Here it's a little more straightforward. So this is a criminal warrant application calendar. So it's a criminal calendar. It's not a civil calendar. And so with it being a criminal calendar, if the case moves beyond this warrant application stage, it is and would, if appropriate, go to a prosecutor's office and end up on the desk of a solicitor general if it's a misdemeanor case, or the DA's office for a felony. So I just want to be clear to everybody that ultimately, if it gets past today, and maybe it does, maybe it doesn't, I'm neutral. I haven't seen or heard anything yet. It's going to be a prosecutor's decision what to do, if anything, with any of these warrant application cases on today's calendar, Friday, any other day. These are not unique in that way, but it's important to understand that dynamic with it being criminal. Also, and this is particularly for any applicant, and so Mr. Underwood, that's you today, you have the burden of proof. And so you as the applicant today have to prove your case for it to move forward. And the standard is probable cause. I can't give advice to anybody, but I guess one way to describe probable cause is a crime probably happened. And so I'm looking and hearing facts and considering different charges. And if you are able to prove each and every element of a particular crime by that standard, probable cause, then you meet your burden. And if not, you don't meet your burden. And so it's all very fact specific, and I'm bound to follow the law. Now, the other side of it, if you are a respondent or representing a respondent in one of these cases, you don't have any burden. And if there is a respondent here, they don't have to testify. And if they don't testify, then I can't make any inference saying, well, they didn't testify because they were hiding something, something along those lines. There's no inference of guilt by someone exercising their constitutional right to remain silent. Or if they're here, they can choose to testify, and they're treated just like any other witness, subject to cross-examination. If they're not here, and it sounds like some of the respondents aren't here, then I'll just hear the applicant's side of the case, subject to any cross-examination by the respondent's lawyer. And that's what I base my decision on. Like I said, I am going to wait, if appropriate. I don't know if there's anybody who's not here who's going to get here. I have to think beyond the normal situation. There's always somebody running late. And maybe this is the one time we don't really have that dynamic. In fact, the marshal had asked, how's the line downstairs? Because we don't have a lot of folks here for a Monday morning. That's fine. I do want to mention, and I suppose this is a conversation, maybe Mr. Underwood, that you have with the, I guess, three or four lawyers in the room, is we also offer mediation. And in most cases, we send the parties to mediation, even if it's something that they maybe have tried or don't think is a good idea. Let me just talk about mediation just for a moment. And that is that we've got a neutral mediator who can decide where the parties are in agreement, maybe where they disagree. Because like I said earlier, if the case gets beyond today, one way or the other, then the applicant doesn't get the final word. It's the prosecutor who decides whether to move forward with a case after consultation with the victim. And so it gives both sides, in most cases, that opportunity. Once parties are in mediation, though, they don't have to agree to something. That part of it's strictly voluntary. And so are those I know there were some ProHack applications, or is that something different?
This is something, this is one of the memorandums.
Okay, I'll get to that.
One of the cases.
Sorry, didn't mean to interrupt y'all. And so anyway, that is something that I'm always wondering about, whether there's any room for conversation or mediation. Because, once this starts, and I'm here specifically, if mediation doesn't work out, to hear the case on its merits or the cases on their merits. So I guess let me start with you, Mr. Underwood, because you are the applicant. It was your action that brought these cases to court here today. Is this the first that you've heard about mediation in these warrant applications, or are you familiar with that process?
I'm familiar, Your Honor. I'm from here, worked at the solicitor's office at Raines Carter's office
Okay.
years ago, so I'm very familiar.
In the city of Atlanta?
Yeah.
Okay.
That's the, when I was a student.
Okay,
Years
yes.
ago.
And, it won't impact anything today, but yeah, if you ever see Mr. Carter, he's a really nice guy. And
He
it's
is.
been a long, long time since I've seen him.
I don't know how he hung around that long, but he's still there.
That's right. And so I don't want to put you or any of the other folks on the spot. I would be inclined for y'all to at least have a conversation and maybe even use the mediator. That's why she's here. And so do you have any opinion or position on that since I bring it up?
Your Honor, I always keep an open mind, but if I'm open to that. But if they're not, we're ready to proceed.
Okay, thank you. And there's no right or wrong answer. I guess I'll start with you, Mr. Brickman. Is there any room for that? I tend to at least want to give folks the opportunity just to see how close or far apart they are.
Your Honor, Mr. Underwood has accused 11 of my clients, 5 of GoDaddy's of felonies. Our contention is that he's made false accusations, and we have no interest in trying to mediate a false accusation of a crime.
And I'm sorry, say the last, you tailed off at the end. I just want to make sure I heard the last part.
We have no interest in mediating a false accusation of a crime other than suggesting to Mr. Underwood that he withdraw his petition.
Well, I do think that, okay, I understand what you're saying. Please go ahead.
I agree with Mr. Britt.
Okay. And so I'll give, it might be easier than, especially given the nature of this calendar. Usually I'm trying to juggle something like this with 10 other cases, and we have the, I guess, luxury of not having to worry about that. It kind of takes two to tango, and so I would just as soon go ahead and hear it. And I think it might be just a better use of everybody's time. And, the court's goal today is just to make sure that everybody has their day in court. And whatever you're trying to convince me of and present, maybe we should just go ahead and do that. Let me ask you logistically then. I would ask, Mr. Underwood, then if you could come forward maybe to the table right in front of you, and then the other lawyers, can y'all sit at the other table? Okay, everybody come forward, and we're gonna go ahead. With a caveat, we're gonna go ahead and swear in if there are any witnesses who might testify, even if they are respondents. Let's go ahead and swear in anybody who might be a witness.
And Your Honor, as an initial matter, you had noted the Pro Hoc applications on file, so those are for Mr. Jeffrey Monheit.
Yeah, let me go.
You're gonna go ahead and grant them?
Let me go ahead and review them.
Okay.
I've seen them.
I think it's gonna go much more smoothly. He has much more knowledge of this case, but I'm happy to proceed. I'm ready if you would like me, but we prefer Mr. Monheit.
Right, I am aware of them. And you're from Pennsylvania, correct?
Yes, Your Honor.
Okay. Yeah, everybody have a seat, except for the witnesses. Let me go ahead and swear in anybody who might. Yeah.
No.
Judge. Maybe mediator.
Yeah.
Yeah.
So that was our only,
All right.
so there's nothing. Good morning.
Good morning. I'll see you at 1 o'clock.
Yeah, sounds good. Thank you.
Thank you.
Right.
Yes.
Do you swear or affirm testimony or updates the court today, the truth, the whole truth, and nothing but the truth?
So help me God.
All right, state your name for the record.
My name is Eric Underwood.
Thank you. And please have a seat. This will take a moment. Let me also say good morning to our pretrial officer, Washington.
Good morning, Your Honor.
Good morning. I just wanted to check in, say hi, and tell you that we're gonna have a hearing. It's gonna last a little while, and I might or might not need to ask you something.
Okay, no problem.
Okay, thanks. Yes. We take up this 4.4 issue. So thank you. That is not. Okay, so there is a ProHack application for 22, 51, 52, 53, 54, and 55. That's
That's
also
correct.
Willis, Butani, Kelly, and Redmond, is that right?
That's right.
Okay. And that is. Sorry, give me just a second. And so everything in this motion, this application is true and correct, is that right?
Yes, Your Honor.
And so I'm just going to ask you, Mr. Underwood, are you representing yourself on this, or do you have counsel?
I'm representing myself, Your Honor.
Okay, and so let me just speak to you. I don't know that it's really an issue for you as the applicant, whether I grant this designation for respondents counsel, but do you have any position on it?
I do. What I have a problem with, Your Honor, is that they were mandated to be here this morning and none of them are. And part of.
Can I interrupt you for a second?
Sure.
I apologize. I might not have asked the question clearly.
Sure.
So the first question is who represents the respondent and whether I should allow a Pennsylvania lawyer under the Superior Court rules to, I think it's 4.4, to.
I would object, Your Honor.
There seems to be a fairly straightforward list of requirements. And so he's proffered, that he's a lawyer in good standing in Pennsylvania and that he doesn't regularly do business here. And that, that there would be no harm to his client for him to represent them here. There's, 4 or 5 elements. Are any of those missing?
They accepted your counsel. I take it. Yes. Okay.
Okay.
Then I would agree with it, Your Honor.
Okay, so I'm going to sign off on that. And I mean, there are other parts to it. I think there's an application fee.
And that has been paid, Your Honor. If Your Honor would like the,
$75, I think.
I think it was over 200 for the first and 78 for the others.
Right, yeah, I know there's an annual and then a one-time. So, I grant it, and you are counsel for these cases, you know, at least for today's purposes.
Thank you, Your Honor.
Okay, anything else on that issue?
I believe that's it, Your Honor.
Okay, thank you. So with that, then I guess the next question would be anything else preliminarily? The whole nature of this hearing is pretty preliminary anyway, but anything that we need to take up first?
Yes, sir.
And I guess you had said something.
Yes, Your Honor. Your Honor, they were mandated to be here. It was clear, concise. The respondents are absolutely entitled to counsel and their due process rights. However, they were mandated by this court to appear. We know they got them because we have their attorneys present. And generally, Your Honor, as you know, respondents have to be in court. And they can have attorneys, but they cannot just not decide to show up. And that is an issue that we need to address, Your Honor.
Or
if we may.
based on, I mean, I will take note that some of the respondents aren't here. So based on that, are you asking me to do anything?
Yes, Your Honor. I'm asking the fact that we have no respondents and their attorneys. I recognize their attorneys, Your Honor, but the respondents were mandated to be here. It was mandatory attendance, Your Honor.
Okay, any response?
Yes, Your Honor. I filed a timely entry of appearance. I am well aware of the fact that the respondents are not here. I am here on their behalf. I don't believe there are any witnesses that the petitioner has, and if he is concerned with the fact that perhaps he's missing out on an opportunity to cross-examine or to even have a direct examination of the respondents, he could have issued subpoenas, because that's made fairly simple in the application that he filled out.
Your Honor, if I may, this is essentially a probable cause warrant hearing. This is essentially, if these individuals are out on the street, they got pulled over on the side of the road by a police officer or a deputy, they are by law detained. And so this is essentially, if they're found that there is probable cause, Your Honor, we don't have any respondents here to be arrested and go to jail.
Okay. Well, let me just say this. We're going to move forward without them here. What I look at in particular is 17-440. And that kind of instructs on these warrant application hearings. And interestingly, the main part of it that protects the respondents is to make sure that I find that they got good notice to be here, so that if they chose to testify, and they'd have the right not to testify at all, you know, they very well could be here today and exercise their rights, and, you know, no negative inference would be drawn from that. Since they are represented and for whatever reason, I do find they knew to be here if they wanted to be here. And the fact that they're not here, it will not keep us from proceeding. Now, to your question, I will say anecdotally that some number of these cases come up where the respondent, for whatever reason, isn't here. And sometimes I only hear the one side of the case. And if the applicant meets their burden, then I do sign a warrant. And then that person ultimately is arrested on that warrant. So nothing would, if you prove your case, nothing would keep me from signing a warrant today, an arrest warrant for some or all of these respondents. You know, I'm certainly not there yet, but that's one of the options I have down the road. So I'll take that as a motion, and I'll deny the motion. Is there anything else that we need to take up at this point?
Yes, Your Honor. Jennifer Burbine, co-counsel with Mr. Brickman. I'm also here. I didn't neglect to mention earlier, I'm here with my colleagues from McGuire Woods, Brian Pumphrey and Shelby Pinker sitting.
Okay.
They are
Good
there.
morning to everybody.
Good morning. We understand
Y'all can
that.
sit, it's okay.
We understand that Mr. Underwood filed this morning a memorandum in each of these 16 cases, attaching a complaint that was filed against the Georgia Secretary of State. It's a civil matter. It's pending in Fulton Superior Court. And we're aware of that complaint. You will hear today that the underlying issue for all of these warrant applications has to do with an IP litigation that was filed in the U.S. District Court for the District of Colorado in 2018, filed by Mr. Underwood against Bank of America. And that case has been litigated. You'll hear that it went up on appeal twice, and I believe at this point has resolved. The issue and what's concerning, and Mr. Underwood is aware of this because counsel in the federal court litigation had advised his attorney in that litigation that there is a protective order that was filed in that case. It's actually the 11 respondents had filed. I don't know if Your Honor has seen it, but we did file a pre-hearing memorandum last week that talked about this, and we actually attached as Exhibit D to our memorandum, and I do have copies if the court should like it. Exhibit D to that memorandum was the docket for the district court litigation. And it's actually at, it's docket number 58 was the protective order that was entered in that case on January 24th, 2019, which talks about the fact that certain testimony documents need to be marked confidential and they're to be used in that litigation only. Mr. Underwood, when he filed his his complaint against the state of Georgia, he included in his complaint documents, deposition excerpts, things that were subject to this protective order, and they were not sealed. So when Bank of America's counsel in the federal court litigation had learned about that, and many of those attorneys, several of those attorneys are actually respondents in this case, you'll hear about that as well, notified his counsel and asked that he either withdraw the complaint or file some sort of motion to seal. And Mr. Underwood, we understand, had some personal issues, and I'm sorry to hear about that, but he was, and so perhaps was not able to do so last week, but we did advise him to the fact that this complaint was filed with things that should have been sealed, which were not. As of this morning, Mr. Underwood filed his memorandum for each of these cases, attaching to the memorandum in this case, that Georgia complaint. Again, it was filed without any sort of motion to seal, any sort of redaction done. So we're asking that memorandum be withdrawn, number one, but if the court would like to entertain it, at least if we could have some sort of redaction or allow the opportunity to have Mr. Underwood seal the documents would be the preference.
And would I do some kind of in-camera review of it so I can decide the applications today, or?
We would prefer to go forward today. It's our position that complaint isn't necessary to make your decision today. I mean, Mr. Underwood may disagree with that, but that would be our position, is that you certainly we could move forward today without even considering that Georgia complaint.
Okay. Yes, sir.
Your Honor, I am aware of the request, and as you know, I had a personal issue, as you're aware of, within my family. And so I did speak with Colorado Council.
I'm sorry, if I could just ask.
I'm sorry, Your Honor.
And if I do want to mention, there's been something about your personal issues. I'm sorry, I don't need to know any details,
Sure.
But my thoughts go out to your family.
Yeah, so it was family member.
I don't know the details, but I'm
Yes.
sorry.
Thank you, Your Honor.
Yes, sir. Go ahead.
But I was made aware of this, and what I was planning to do and working with the court e-file system is to get it from public view for right now. But it would be something, Your Honor, that you would need to look at in camera, because the complaint that was filed, which she's speaking of, Judge Belinda Edwards, Your Honor, is going to hear this Friday elements of a case in a civil case. So my trademark was canceled by Bank of America and these respondents, but it was canceled under racketeering, fraud, and all the things that we're going to talk about today, Your Honor. And it's under Georgia law, the racketeering statute forbids any illicit profits or illicit gains from illegal activity. And so I had to create an action, Your Honor, to do a declaratory judgment against the Secretary of State to get that reversed, because we proffered evidence, Your Honor, that Bank of America and all of these defendants, all 16, engage in illicit criminal behavior. In fact, Your Honor, when we get to this case, you wouldn't have to take my word for it. The U.S. Justice Department issued a memo, and they say it's sufficient evidence.
Okay, thank you. I do want to be clear, though, with Judge Edwards' civil case this Friday, is the idea still, you know, it's on the one hand, it's apples and oranges, and on the other hand, I do want to make sure that one process is not being used in some way to influence another process. And so is everybody on board that I'm going to go ahead and hear this criminal application today?
Yes, I will say, Your Honor, that we will take steps to address counsel's concerns. I flew in from Colorado to be here, and so it's been hectic with all the family stuff going on last week. I'm trying to do the best I can, and we will try to address these concerns. But definitely, what was attached is essentially, Your Honor, the very same blueprint, because what Judge Edwards is going to hear is the criminal nature in order to not only give my trademark or order the Secretary of State to reinstate my trademark, Your Honor, but also what's also on the docket is an injunction to stop Bank of America from using Erica, which now has 50 million users across the U.S.
Okay.
Your Honor, and just to clarify, Bank of America is not a party to that, the matter pending before Judge Edwards. That's against the state of Georgia. So we're not in that. We certainly want to proceed today, but we would ask that the court, if we can, if Mr. Underwood could maybe perhaps withdraw his filing and redact it, would be appropriate.
What I would, Your Honor, suggest is that we use it today, and then we can redact it or address those concerns. But all those figures and exhibits that they're speaking of, Your Honor, that shows criminal activity, which is why I attach it in the first place. It's all criminal in nature, Your Honor.
What I would rather do is just kind of take it up as it comes. But any response, anything else before we get started?
I would just add that Mr. Underwood is certainly welcome to reference those documents, but without actually using them as exhibits or anything like that.
I understand. You know, I look at this strictly as a warrant application under the rules of evidence. And so if something comes up, you know, if either side wants me to look at something, I'll consider objections, you know, as they come up. It's very hard for me to think about it kind of in the abstract before I see stuff and I put it in the right context. But, you know, I'll consider both sides of anything like that. I would ask that, you know, that both sides consider what is the most direct approach to present my case or defend my side of the case so that I can make an informed decision. I do want to kind of get started on it, but I don't want to rush out. Is there anything else before petitioner presents his case?
No, Your Honor.
Okay.
Your Honor, just one housekeeping matter, which was that on Friday, my office on matters 2251 through 2255 filed a motion for continuance, in part based on the pending pro hoc for myself. We will withdraw that request for a continuance.
Got it. Yeah, I've approved that. And so I won't rule on your motion for continuance since it's not in front of me. Okay. And so is there any brief opening that either side wants to give, or do you want to just call your first witness?
I'll give a brief opening if I may, Your Honor.
Yes.
Your Honor, this is a criminal RICO case under OCGA
14-4 with other predicate Georgia criminal laws. This case, Your Honor, is considered to be one of the biggest IP theft cases, not only in Georgia, but in U.S. history, in terms of value and money profited by respondents. Any characterization by respondents that conduct was permitted during the ordinary course of litigation belies what the DOJ and other agencies, including agencies right here in Fulton County, Your Honor, have not only concluded, but are still engaged in probes because it crosses so many jurisdictions and authorities. There are also stunning omissions that you will see for yourself, Your Honor, in the form of a deposition by a woman who is actually one of the respondents, Keena Willis, who admitted that it was counsel who told her to say something in a declaration and not from her own personal knowledge. We have emails, Your Honor, that show a pattern of racketeering from Bank of America all the way to those at GoDaddy. This court should be warned that the respondents will try and relitigate the trademark infringement case, which is still ongoing and it has not resolved. Instead of focusing on serious criminal accusations that are governed by Georgia law. This court should not be distracted and should hear the probable cause standard for arrest to be warranted on today, Your Honor. The petitioner, who is the prosecutor of these warrants, is also prosecuting all the warrants for the named individuals, as we mentioned today. Notwithstanding strong, decisive, and clear criminal evidence that will go beyond probable cause threshold and standard, this court should know, as we just discussed, that Judge Edwards has agreed to hear a hearing to reinstate something that the respondents have taken away from me, including putting an injunction on the respondent, Bank of America, from use of Erica nationwide. This hearing purpose is multi-layered and is to be determined whether the 16 individuals mentioned above engaged in racketeering. And OCGA -4, Your Honor, says that it should be unlawful for any person through the pattern of racketeering, activities or proceeds derived therefrom that acquires or maintain directly or indirectly any interest or in control of any enterprise, real property or personal property of any nature, including money. The theft of the Erica trademark, Your Honor, is generated multi-billions of dollars for Bank of America. In fact, one quarter last year in 2023 generated $7.5 billion. Under Georgia law, I'm entitled to reclaim every single profit and money that Bank of America has received. In fact, Your Honor, one of the reasons why we're here is because while they were engaged in racketeering and in a criminal enterprise, they canceled the Georgia trademark that is in question, that is of the subject. And that trademark has great value. And so the petitioner is seeking the arrest of all 16 RICO participants through due process, that no one is above the law. This court should dismiss any argument that respondents' conduct was ordinary during the course of litigation. And Your Honor, they're going to go through, well, this lawsuit was filed in Colorado and there was an action out there in Arizona, which we were dismissed because we knew what we had to do in order to seek justice, which is why we're here today. No one can commit serious crimes and then hide behind litigation privilege in order to shield themselves from the consequences of possible criminal indictment. We therefore, Your Honor, ask that you hear the facts And I will leave it to the respondents.
Before you go, I just want to understand your warrant applications. You know, you allege, and I'm imagining that all the applications are similar.
Yes.
I'm looking at one of them right now against Robert Barram. And so you allege RICO under 1614-4, and you say while committing the.
I'm sorry about my handwriting, Your Honor.
No, it's okay. What is the underlying or related crime that you're saying was committed?
Conspiracy,
RICO?
conspiracy, theft. I have my.
Is there 2 or 3 steps to any analysis I give,
Sure.
you know, under that statute?
Sure, absolutely, Your Honor. There is, well, first they formed a conspiracy from outside.
To do what?
A conspiracy to falsify evidence. So the Erica trademark, Your Honor, it was hosted on a GoDaddy server, and I came before Bank of America. The trademark initially was in Georgia, and that Georgia trademark extends beyond to the present day.
I apologize for interrupting you. What code section are you asking me to look at?
Oh, sure. It's 16-14-4, Your Honor. It's the Georgia RICO statute.
Okay.
And under that statute, theft, bribery of a witness, which we'll discover, or which we'll talk about today, fraud, mail and wire fraud, which applies, false statements, Your Honor, filing false documents, perjury, subordination of a witness, and evidence tampering. Mhm.
Anything else by way of an opening statement?
No, no. I'll,
Thank you. Please have a seat.
yes.
Any other openings?
Yes, Your Honor. Okay, great. Good morning again.
Good morning.
There is no evidence that any crime was committed by any of the respondents who are named in Mr. Underwood's applications. The court, in one of the questions to Mr. Underwood, asked if they were similar. They're identical. Each of these applications are identical verbatim. He has in no uncertain terms alleged that these 11 respondents committed RICO violations. He has mentioned twice now the fact that this had to do with Bank of America canceling a registration, as the court may very well hear through Mr. Underwood's testimony. A registration was canceled by a court after the IP litigation was concluded in favor of Bank of America, and as a result of that order by the court, the court ordered that the Secretary of State cancel a registration, which they did 3 days later. This is a criminal case. We're not here to rehash the IP case because the IP case was resolved after 6 years of litigation, during which Mr. Underwood had competent counsel, went all the way up to appeal. He lost the appeal. The registration was canceled. And this case is just about whether or not a crime was committed. I'm a criminal defense lawyer. I'm not an IP lawyer. I'm very well aware of what his burden is. There is not going to be any evidence, credible evidence, put before the court this morning that any crime was committed by any of these respondents, much less on August the 2nd, 2019, which according to Mr. Underwood was the date of the incident. He is alleging that this crime occurred, according to his handwritten application, that the crime scene, if you will, was the Georgia Secretary of State's office. That occurred, he said, on August the 2nd, 2019, which is almost 5 years ago. It's my understanding that he is the only witness today, and while Mr. Underwood certainly has the opportunity to testify on his own behalf, he has already made reference to documents and depositions and emails. While hearsay is admissible at a warrant application hearing, we will be objecting if he attempts to try and introduce documents, depositions, emails that no proper foundation can be laid. he can't simply get up and start talking about how all these horrible things have happened without introducing the evidence the proper way. So at the end of this hearing, we'll be asking you to dismiss each of his petitions on behalf of the 11 respondents I laid out earlier this morning.
Okay.
Thank you.
Please call your first witness.
Your Honor, may I give a brief opening?
Yeah.
I apologize. Thank you.
Well, you kept saying the 11, so I thought you were speaking for everybody.
No, I'm not.
Okay,
There's 16 total.
16 total. My apologies.
No apologies, Your Honor. Good morning, Your Honor. My name is Jeff Monheit, and I represent the other 5 respondents that are all current or former GoDaddy employees or officers. We agree with everything that Mr. Brickman just related to, Your Honor. In addition, GoDaddy in particular and its employees has no business being here. What you'll hear today is that in Mr. Underwood's litigation against Bank of America, GoDaddy simply responded to 2 non-party document subpoenas, one that was issued by Bank of America and one that was issued by Mr. Underwood. Mr. Underwood, and through counsel, subsequently noticed a deposition of one of GoDaddy's witnesses, and that witness appeared for a deposition. That's Ms. Willis. That was all of GoDaddy's involvement in the underlying case. Mr. Underwood subsequently filed a civil action against GoDaddy and Ms. Willis in state court in Arizona, in which I represented GoDaddy and Ms. Willis in that case. We filed a motion to dismiss and a motion for Rule 11 sanctions, and Mr. Underwood voluntarily dismissed that case with prejudice. And so in addition to there being no evidence of a crime, this is simply another attempt by Mr. Underwood to relitigate his losses in the prior cases, to attempt to get another bite at the apple. The only other point I want to make at this time is that Mr. Underwood claims that this case in particular that we're here for today concerns the cancellation of his Georgia registration. And any allegation as to GoDaddy has nothing to do with the reason that the district court canceled that registration. What you're going to hear is that the district court granted Bank of America's counterclaim to cancel that registration because Mr. Underwood could not show that he was using that mark as of 2010, at the time that he filed the application. Nothing that is alleged to have occurred with Mr. Underwood's customer account with GoDaddy happened in 2010. Rather, the website that Mr. Underwood claims that he had with GoDaddy, he does not claim that he began hosting until 2015. And so there is no reason for GoDaddy or any of its employees to be involved in this case whatsoever. Thank you.
Thank you. Now, please call your first witness.
I guess it'll be me.
Yes, and we don't have to do it in some kind of awkward way.
Sure.
Use the witness. If you're comfortable just sitting there,
Sure.
you can just, you certainly understand that you're subject to cross-examination. Any of the lawyers can ask you questions. I could ask you questions.
Or can I just present, or do I just have to?
Well, I think it's going to be both. You can certainly present as you're direct. You don't have to ask yourself questions.
Okay.
But before you get started, I do want to be clear that I think that the lawyers would be entitled to a cross-examination.
Right, which is unfair is that their clients aren't here, which they, are. Well, we'll proceed, Your Honor.
I understand.
Yeah.
If there's, just going back to that issue just for a moment, I've already ruled on it.
Yeah.
But if there's any legal authority that I should consider why you as the applicant should not be subject to cross-examination because their clients aren't here as respondents, I'll consider it. I just,
Sure.
Respectfully, I don't see that. That's a separate issue.
Right, I understand, Your Honor. Nothing comes to mind. I was expecting, they absolutely had the right to remain silent for this hearing, but the only way this case gets presented and for you to hear the evidence, Your Honor, is for me to speak. So I would say this, Your Honor, I should be granted the same luxury as counsel for the respondents, who they get to just talk on behalf of their clients, Your Honor, and they don't need to, and they're not cross-examined. And so I would just put that stipulation out there. If the court finds that reasonable, I would just like to present versus being cross-examined, since I don't have that luxury I don't have the luxury of cross-examining any of them, and they're not even here.
I understand. Any response from any of the respondents, counsel?
We're ready to proceed.
Okay. Anything else?
Nothing further at this time, Your Honor.
Okay. Thank you. Let me let me start, Mr. Underwood, just by asking you a couple questions from the bench. They're more administrative.
Sure.
So it is true that you are the applicant on these 16 warrant applications, correct?
Yes, sir.
And they're all, it's the entirety of this calendar, 1 through 16.
Yes, sir.
I have pulled up all of those applications. Every single one of them, everything that you put in them, is it true and correct?
It is true and correct, Your Honor. They acted in conspiracy.
Thank you. And other than the names, the people who you're applying for these warrant applications against, it's a different person on each of the 16 applications. Is the allegation itself essentially or identically the same for each one of the 16 people?
Essentially, Your Honor, RICO is you can charge everyone with the same thing. And as you know, the Georgia standard is broader than the federal standard. Yes.
And so let me just ask, the alleged incident date is August 2nd, 2019. Is that correct?
The alleged date was a mistake, Your Honor. It should be the 19th when it was canceled by the Georgia Secretary of State.
August 19th, 2019.
Yes, that's when it was canceled, Your Honor,
Okay, thank you.
by the Secretary of State.
And this is Fulton County Court, and the address you list, 214 State Capitol, is that the Secretary of State's office?
Yes, sir.
And that's located in Fulton County? Correct?
Yes, sir.
Thank you. And the people who you are applying for warrants against are, and I'm just going to list all of them, but I want this to be part of your testimony, just so that it's on the record. You're applying for warrants against, and if you could just say yes or no to each one, they are against Robert Bahrampour.
Yes. Yes.
Nicholas Beiser,
Yes.
David Bernstein,
Yes.
Aman Bhutani,
Yes.
Jeremy Feebleson,
Yes.
Jared Kagan,
Yes.
Nima Kelly,
Yes.
Christian Kitchell,
Yes.
Brian Moynihan,
Yes.
Thong Nguyen,
Yes.
Jim Pastor,
Yes.
Justin Redmond,
Yes.
Mary Suter,
Yes.
Meredith Verdone,
Yes.
John Walsh,
Yes.
Iana Willis.
Yes.
Okay. Tell me what happened.
Your Honor, what happened was I owned a trademark. It was registered in 2010 by the state of Georgia. And it's called Erica. Erica is a trademark. And I'm going to keep things simple. I don't want to get into all the trademark litigation that's still ongoing.
And Erica is ERICA.
Yes, yes, Your Honor.
Go ahead.
And it's a trademark that I used as a personal assistant and search engine. And essentially, back when I found out, I'll just get to the action part. I just want to establish that I owned it and everyone agrees that I registered it in 2010 and that I owned it through the registration. I found out, Your Honor, that Bank of America was using the trademark through an announcement. So I sent a cease and desist letter to Bank of America. And it wound up with Robert Bahrampour, Your Honor, who was the lead person at the time for Bank of America. And he sent me a letter that I have that stated that it was conciliatory and said, we don't mean to infringe on anyone. I'm paraphrasing, but I have the letter, that we don't mean to infringe on any trademark or IP. And they wanted essentially to work it out and fly me to New York and to work it out, which I was amenable to, Your Honor. Unbeknownst to me, they were applying for a federal trademark at the time. And Robert Bahrampour kept stringing out the times and the dates of when we can meet. And I'll show you how this all ties together to all 16. So eventually, when they kept on, for lack of a better word, jerking us around, we had to file a federal action in Colorado. which was a diversity case of state and federal action or statutes. So so later we learned, Your Honor, that it was just a ploy to get Bank of America's trademark registered because it had not been finalized at that particular point in time when we sent the cease and desist letters. And they were obligated by the USPTO. And in the cease and desist letter, Your Honor, we stated the Georgia trademark as our authority for infringement. So Bank of America and I are initially in the first part of the litigation, about a month or two into the litigation, we had settlement talks. I was always willing to license it to Bank of America.
Excuse me, Mr. Underwood, I'm sorry to interrupt. If Mr. Underwood intends to start speaking directly about negotiations, I would ask that he not be allowed to do that under the applicable civil rules, if those are absolutely inadmissible about any pre-trial or pre-hearing discussions about resolution.
Well, let me ask this.
Sure.
I'm interested in relevant
Sure.
evidence to your application. And that's why I wanted to kind of frame it up front that you want me to sign arrest warrants for 16 people
Right.
based on something that happened at Georgia Secretary of State's office.
Yes.
So maybe there's a way to put things in context and tie it together. For now, I'm going to sustain the objection on relevance grounds and ask you, even if it's a matter of kind of working backwards, what does this have to do with anything done across the way at the
Sure.
Secretary of
Across the
State?
street, essentially, or up the
Right.
block. Yeah. So essentially, Your Honor, Bank of America through Jared Kagan, Jim Pastore, Jeremy Feigelson, Nicholas Beiser, Keena Willis, and Justin Redmond. Aman Bhutani comes later. Essentially, Your Honor, Bank of America was in a pickle. I came before Bank of America's use of trademark, and they needed to find a way to make me come after Bank of America, so to speak. So my records were hosted at GoDaddy. Let me just, for a foundation, Your Honor, let me start. I went to GoDaddy in November of 2018, and this is very relevant, and I'll tell you why. In 2018, of November 2018, I went to Naima Kelly and asked for a declaration to prove that I came before Bank of America. Her response was through a gentleman by the name of Robert Kelly. I'm sorry, Robert Cannon. I'm sorry, Robert Cannon, who called me on behalf of Naima Kelly. And he said that we cannot enter lawsuits. It's our policy that we don't give declarations or affirmations of anything, just use your records. He told me how to obtain my records, but they said they don't get involved in lawsuits for anybody, quote unquote. So during the course of litigation, we found that we found out that Bank of America submitted a declaration by a woman named of Keena Willis from GoDaddy. In this declaration, Your Honor, in Keena Willis's declaration, she put that I began hosting.
Your Honor, I'm sorry, Mr. Underwood.
What's the objection?
Double hearsay. I know hearsay is admissible in warrant application. Excuse me, sir. Let me finish. I know in warrant application hearings, hearsay is admissible. It's like double hearsay of talking about exhibits. You can't just simply start mentioning exhibits and their contents without any sort of foundation at all. This court has no idea what those are contained in those exhibits. And more directly to the court's original point to Mr. Underwood.
Give me the Keena Willis's
I would ask Mr. Underwood
declaration.
to focus the comments on what is the evidence of the crime that he allegedly occurred on August 19, 2019, down the street, the Secretary of State.
Your response?
My response, Your Honor, that is relevant because it's under false And she submitted a false declaration, Your Honor, and we had to investigate it at the time, which we subsequently obtained a subpoena. And we had a deposition, which she admitted to her part in this, Your Honor.
What about the double hearsay part of it, though?
I don't agree with the double hearsay. Mr. Brickman admitted that hearsay is admissible, so, but the double
But what if
hearsay.
it's compounded? It's two layers and it becomes less reliable.
Your Honor, if Mr. Brickman would like me to lay foundation, I'd like for him to specify what he would like me to lay foundation for.
Okay. So two things. One is I sustain the objection. And two, I'm not saying I want to allow something if you lay a foundation and it's relevant. But again, I still haven't seen, and I want us to be able to time box this entire hearing
Sure.
in a reasonable way. You know,
Sure.
at the most, and I don't even want to throw out a number, you know, because I'm afraid that we'll double it. But
Sure.
you know, I want to give everybody their day in court.
Sure.
With an understanding that at most we have a couple hours.
Sure.
You know, at most. And so with that, can you maybe jump ahead for a moment and just tell me,
Sure.
what did any one of the 16 people do over at the Capitol?
That's correct.
Just for the record, we would just ask Your Honor to strike Mr. Underwood's description of the declaration as false, given your sustaining Mr. Brickman's objection to the testimony about the alleged declaration.
Your Honor, I object because that's part of why we're here, is the conduct and the participation of all 16. Each had a different role in what brought us here today, Your Honor.
I understand. And it's a little vague because you are the lawyer asking the question and you're the witness giving the testimony. And it's hard for me to separate a little bit what's evidence. So I'm taking everything you say as evidence. So I am going to overrule the objection with the understanding that it is your opinion as an advocate in this case and a party in this case. So I'm not necessarily agreeing with that characterization, but I think it's fair for you to put it that way. So, you know, for what it's worth, I am going to overrule the objection. But I do want you to, if you can, help me, because ultimately at the end of this, if I don't see the connection and I don't understand
Sure.
what anybody did in Fulton County in 2019, then I'm less likely to agree with your ultimate argument.
I understand, Your Honor.
And I'm patient, but up to this point, I've not seen the connection.
Sure. The crux, Your Honor, is the date. A date, Your Honor.
Yes.
It's a false date, Your Honor. And it was through conspiracy of these individuals to falsify a date, Your Honor.
Now, are you saying that this goes back to you? You know, basically BOA, in so many words, stole your idea and got
Yes.
a patent, and there's been litigation over that. You went to GoDaddy for a declaration. They said they would not give you a declaration, but they ultimately gave a declaration
Yes.
against you.
Yes, they did, Your Honor. And
Okay.
unbeknownst to me, which was a conflict of interest, Jim Pastore, which we learned later, it wasn't even disclosed in her declaration, Your Honor. He was also not only counsel for Bank of America, but also counsel for GoDaddy as well.
Okay. Go ahead.
And essentially, Your Honor, these people went to Keno, the persons that I mentioned, they went to Keno Willis and essentially asked her to lie in a declaration on a date that my Georgia trademark is tied to, Your Honor, which the website my24erica.com is licensed between Erik Underwood and a company called my24hournews.com, which gives permission. So that ties it all together, Your Honor, if that is any clearer. The date, when we saw this declaration that we're talking about, Your Honor, the date, instead of the launch of the website, which we know it to be March 2015, Miss Keno Willis put June 2018. Bank of America launched their Erica or has a priority date of October 2016. So you see, Your Honor, she put falsely in a date to make it look like I was coming after Bank of America, when in reality, I came before Bank of America. And in this trademark, Your Honor, you have to come before the person, not after the person, in order to have superiority trademark rights. So these individuals schemed in a conspiracy and while they were doing that in the conspiracy, they were trying to cancel the Georgia trademark in the midst of this conspiracy, Your Honor.
Do you have the paperwork showing what they did?
I do. I have an email. Do we have the emails?
I thought you were saying it was some kind of filing with the Secretary of State's office.
Oh, of the trademark, Your Honor?
You're saying, I think, that this group of people conspired and then lied to the Georgia Secretary of State.
No.
About something related to this. Is that
Sure. No, Your Honor. These group of individuals lied and conspired to get the upper hand in litigations by submitting false documents in order for my Georgia trademark to be canceled.
And do you have those false documents with you that I can look at?
Let's see. Keno Willis's declaration. Number, no, that's the deposition. That's Keno Willis's declaration.
And please don't feel like I'm not ordering you or, telling you to provide something. I'm simply
Oh, no,
saying,
I want to proffer this.
talk about this.
Sure.
If
Okay.
it's documentation, now would be the time for me to see it.
Okay, so Your Honor, I do not have her actually, the declaration, Your Honor, was filed this morning at the clerk's office, which they spoke of the declaration. But I do have her admission on the transcript that that has no knowledge of the date, Your Honor.
But I'm not, please just go ahead.
Sure.
I don't think is there an objection at this point?
Only to the extent that I believe the deposition, I'm not sure about the declaration, but definitely the deposition transcript is subject to the protective order that was issued by the District of Colorado.
I'm simply saying if there's a conspiracy allegation involving something that was filed with, say, the Secretary of State's office as an example, then that would be something that one or both of you might want to know. And if you don't have it, that's okay. It's just, as the fact finder today,
Sure.
My curiosity is such that if you have it, I'd like to see it. If you don't have it,
Sure.
don't worry about it.
Your Honor, I can't place my hands on Keno Willis's, but it has been filed with the court. It's one of the exhibits that was attached to the declaratory action against the state as an exhibit, and it's in one of the exhibits, Your Honor.
Okay, but please understand, I don't go back and look at the record.
I understand.
I'm only considering what's being
I
presented
understand,
in
Your Honor.
court today.
Yes.
Okay.
So at this, once we discovered that she obviously falsified a date, we subpoenaed and had a deposition. I will proffer this as evidence, Your Honor, that this is in the Lay Foundation. In this deposition, we're talking about her false date in her declaration that she submitted to the court. And as I mentioned before, there were several people by name that I mentioned that had a hand in the conspiracy to get her to falsify this evidence, which ultimately affected my Georgia trademark right here in the state of Georgia, Your Honor.
Also, how are they?
How were they involved? They emailed Ms. Keno Willis and they on the phone. We even have an email from Jared Kagan that said he liked to discuss something, but he rather discuss it via phone versus email, because she actually asked him, well, why don't you just send it over? So we have a pattern of conspiracy and racketeering from concluding. And keep in mind, Your Honor, I'm the GoDaddy customer who asked for a declaration, and they said, we don't do it for anybody. And yet they are doing this for Bank of America and also providing false information, knowingly through subordination, providing false information. And at this deposition, Your Honor, since I laid out the foundation, there was a date in question. Also, and pull up the receipts as well.
Your Honor, just for the record, I would note an objection to Mr. Underwood's characterizations of documents. I believe Mr. Underwood has made reference to emails and is now attempting to make reference to a deposition transcript. Those documents speak for themselves, and if Mr. Underwood is not able to admit them directly, he certainly is not able to offer opinion testimony about the contents of these documents.
Your Honor, I have personal knowledge because I was at this deposition as an observer, and I have a transcript that is reflected on my observation at this hearing, Your Honor.
Now, are you offering these just to show that they happened, or what's in them?
What's in it is her admission that she does as you know, Your Honor, when you do an affidavit or a declaration, you're swearing that this is your personal knowledge and that you know that all this to be true and absolutely correct. She admitted in this declaration that she had no personal knowledge and that in fact, she was told to say this by Bank of America's attorneys and all the conspirators that are mentioned here, Your Honor. And she admits that, Your Honor.
But you're trying to introduce evidence about her comment on something, but I haven't seen the actual declaration.
Yes, Your Honor.
So until I see that, I think that you would at least have to present that before we get to the next
Sure.
step. Excuse me.
How can I get this to you, Your Honor? The declaration for.
Well, I can only react to what's presented to me.
Sure.
I'm sustaining the objection at this time.
Okay.
Please go ahead.
So on my personal knowledge of having attended this hearing, Your Honor, she said that when asked about the date in question, my24hournews.com, which is where the Erica IP is hosted. Do you have knowledge whether it was hosted prior to June 27, 2018, which is in her declaration, Your Honor? She says, no, I do not have knowledge of it being hosted prior to that time. And question, and so can you definitively say it was not hosted? No, I cannot. It could have been hosted elsewhere. And then
I'll make the same objection based on Your Honor's ruling on the prior objection, that Mr. Underwood is attempting to read documents into evidence rather than presenting those documents.
I will present this document, Your Honor. And I understand that you want the declaration. I filed this declaration this morning at the clerk's office, and I unfortunately do not have a copy.
If you filed something in the in the clerk's office today that you want me to look at, then I'll consider it subject to an objection.
Yes, it is filed, Your Honor.
So we're talking about two different things.
Sure.
Let's just jump ahead to that for a moment. If there's something that was filed today that you want me to look at, customarily, the other side can look at it and review it. And if they're okay with it, I'll look at it. If they object to it, I'll take up the objection first. So we've got that. And then on this other issue, though, as I understand it from our Pennsylvania counsel, that they don't want me to look at the transcript. They're saying you can't get around it, correct? You're saying you can't get around the introduction of this transcript by talking about it without introducing it, and you object to it being introduced.
That's correct, Your Honor.
So, we have to get to the underlying issue of the admissibility. I do sustain the objection that you can't go into the details about something before I rule on the underlying something. And so I think that that's something I'd like a proffer on it first, because I kind of feel like even if we go through all these steps, does it really go to the issues before the court today?
It does.
Anyway.
It does.
So let's pause for a moment on the admissibility of this transcript. Let's do this. I want this to be orderly and understood if anybody's reviewing this later. Are you marking this transcript?
I am marking this transcript as Exhibit 1, Your Honor.
Okay, so it's gonna be applicant 1, A1, just like the steak sauce. So applicant 1, and have you seen that? Is everybody talking about the same thing?
I can
Can you share that
absolutely.
We have
Your
not
Honor.
received
with
the
the
copy.
lawyers on the other side? And I'll ask the marshal, are you okay if he hands it, or do you want to do that? Okay, so you're showing A1 to defense counsel. If y'all need however much time to look at it, just let me know.
Your Honor, I'd just like to note that this deposition transcript is subject to the protective order from the U.S. District
Okay,
Court.
so I need to understand. So what is A1? Just what's
Your
the?
Honor, that is.
Can we do this though? We have to do it a more organized way. What is A1?
A1,
It's a deposition transcript
yes, A1 is a deposition transcript, Your Honor.
from, what's the date of the transcript?
The date of transcript is August 2nd, 2019.
Okay, who is giving the deposition? Who's being deposed?
It's Keena Willis.
Okay, and what is this pursuant to? Is this a deposition as
This is a
pretrial part of a case?
Yes, this is a deposition with her false declaration in question, Your Honor.
Okay, and is there a case number for that underlying case?
Yes, the case number, Your Honor, is 18 CV 2329 PAB MEH.
And where is that?
This is in a District Court of Colorado, Your Honor.
Okay, and is that the same Colorado case that y'all have mentioned and referenced?
Yes, sir.
That at this point is closed?
No, it is not closed. That's false, Your Honor. None of the appeals have run yet.
Okay,
And
I
so-
think they say it's
Maybe in their minds, Your Honor.
right, but
it's
in
not.
your mind, it's open, but we're talking about the same.
No,
case.
yes, we are.
Okay, and so I need to understand your proffer. So Ms. Williams, and I'm not considering it at this point, I can separate the two. What would she say in that? Like, what's the allegation?
She admitted, Your Honor, that the dates and some of the pertinent information that we raised was told told to her from someone from the other defendants.
Okay,
So-
leave it at that. I
Yeah.
just need to understand the 30,000-foot view.
Sure.
And how does that relate to your warrant application today, where you're alleging something happened at the Georgia Secretary of State's
Because,
office
Your Honor,
in 2019?
Sure, because Your Honor, in the RICO statute, you cannot be engaged in racketeering, profiting, illicit or illicit, indirectly or indirectly. Just paraphrasing the statute, Your Honor, that I read earlier. They, during all this, Bank of America submitted motions to cancel my Georgia trademark. They were engaged in illicit criminal activity.
Okay, pause just for a moment. Any response? I'm just trying to get a threshold idea. It's, in a lot of situations, I think better and easier, I don't want to say easier, better and more effective, just to consider as much evidence so I can make an informed decision. And so what is the objection to me hearing this?
Oh, just, my objection is that particular deposition transcript is subject to the protective order that was issued by the District of Colorado Court.
Right.
And Your Honor, my only additional objection would simply be that we object to Mr. Underwood's characterizations of this deposition transcript, which I think Your Honor has already sustained. And just note that the Exhibit A1 is not a complete copy of this deposition. It is an excerpted portion of the deposition.
Yes.
Thank
Do you have the entire deposition?
I do, Your Honor, I'm trying to spare the court time. This is
And just, let me ask though, I'm interested in this idea of this document being part of a protective order in a case that now is
Yes.
closed,
No,
according to you. So why shouldn't I consider something that had a protective order on it a few years ago on a closed case? Is it sealed forever?
I don't personally have a copy of the protective order, but my understanding is that that protective order continues beyond that litigation.
Right. And does a protective order prohibit someone who feels that he's been the victim of a crime, not using that in some way later in a court of law to make his case?
I tell you, for any protective order that I have been a part of on either side of the courtroom, a protective order is in place until a court orders otherwise.
Right.
I mean, it's not for us to say, well, let's carve out this little exception for Mr. Underwood. I mean, my other objections as to relevance too, because at some point we're going to get to what he alleges happened on August 19th of 2019. But my understanding is that a protective order that's entered in a case by a court that's presiding over a civil matter in Colorado will remain a protective order and remain protected until such time as that court rules otherwise.
And
In fact, we know that there's a concern because the counsel for the bank has already been in touch with Mr. Underwood's prior counsel, telling him, look what he's doing down in Atlanta. This needs to stop.
And Mr. Underwood, let me ask you a question. So do you agree or disagree that there is a protective order or was a protective order related to A1?
No, there is no protective order on A1, Your Honor. This is public in the Colorado case, Your Honor. There's no protective order on this deposition.
Right.
And what they're speaking of, so we can make distinctions here, what they're talking about is discovery items that we received from Bank of America, not a transcript from a deposition, Your Honor. This is public in Colorado right now and it's public elsewhere.
Okay. Any response to that? I just want to make sure that before I take up Mr. Brickman's argument about something that is protected, he says it's not protected.
Our understanding from the attorneys that represented Bank of America in the Colorado federal court litigation is that the deposition transcripts absolutely were part of the protective order. And to the extent that they were filed, they most likely were filed under seal or redacted in some way.
So we've got to move on. What I'm going to do is take this issue under advisement and I need to understand the relevance of it. And I think y'all can talk around it and make kind of a general statement about it. And I don't necessarily have to get to that issue. In other words, if we get to the end of the hearing in a little while and I get the gist of what it is without it being admitted, if it's not relevant, then I don't get to that question. And if I do find totally open-ended, situation right now, and I'm open-minded about it too, that I will consider that. But let's just kind of see where it goes first. So I'm going to take that objection under advisement, and I'm going to instruct you, Mr. Underwood, at this point, I feel like if you say anything else about it, we're getting into that murky area. So I'm going to ask you to move on.
Sure, absolutely. So may I proceed?
Yes.
In this deposition, Your Honor, she ties, in this deposition excerpt, Your Honor, it ties to the crux of why we're here, because
I feel like you're getting into exactly what I was asking.
Oh, I'm
you to
sorry.
move on from.
If I can't discuss anything in here, Your Honor, is that?
What I would ask you to do at this point, and I'm not telling you to do it.
Sure.
I'm going to sustain objections otherwise, is that, you've established that there is this deposition, when it was under A1 and, excuse me, on August 2nd, 2019, and based on things that Ms. Williams said in that deposition, here's how these other people got involved, and here's where it ultimately led to the Georgia Secretary of State's office at the Capitol. So, I know that there's a lot more to what's in that deposition, but based on that, what happened that leads us to the allegations today?
Yes, the Georgia law prohibits anyone who engages in racketeering to receive any kind of benefit, Your Honor. So the benefit would have been the cancellation of the trademark because it threatened Bank of America, and then Bank of America would not have been able to use their trademark.
Okay. And did that happen?
It did happen, Your Honor.
Okay.
It did. Also, we discovered, Your Honor, that the person who procured Ms. Willis to get involved with Bank of America was also outside counsel for GoDaddy and Bank of America, which was a conflict of interest. And that was Jim Pastore, Your Honor. And Nicholas Beiser, who worked at GoDaddy, Your Honor, he was general counsel for them. He and Jim Pastor approached Ms. Willis about doing this, along with Mr. Kagan, Your Honor.
I'm just stretching.
Okay.
I'm not-
You okay?
Yeah.
Okay.
They never tell you when you became a judge that you said a lot. Go ahead.
And so when we learned this, Your Honor, briefings had been closed. We couldn't enter, as you know, any new information. So the subsequent trademark was canceled while in the midst of their racketeering conspiracy and the stuff that I mentioned earlier, Your Honor. So that is the crux of it. Georgia law, and if we can focus on this, because they want to keep getting distracted in other stuff, Georgia law prohibits any pecuniary interest of gain from any illicit activity from racketeering.
Okay.
And that is part of what happened at the Secretary of State, because the end result, Your Honor, while they were engaged in this activity, they were forbidden by Georgia law to cancel the trademark, Your Honor, and which is also the subject of why Judge Edwards is reconsidering or considering restoring my trademark.
Do you have that case number?
I do, Your Honor, and I think that would be very helpful. I think that would be very helpful for you to have it.
I tried to pull it up.
Okay.
Based on your name, but I didn't see it. If you have that number.
Sure. Let's see here.
If it's not readily available, I'd ask you to continue.
Okay. I think I can pull it up here. The case number is, Your Honor, if you're ready. It is 24CV 007 809.
Thank you. Please continue.
Yes. And so when we learned this, Your Honor, Bank of America through Jared Kagan submitted the paperwork to cancel it at the Secretary of State's office. And so we find ourselves at a juncture where we had to either, file something where we could try to get something resolved in the Colorado case, which has not been resolved, Your Honor, yet. And so I got law enforcement involved shortly thereafter, the following year. And they have taken a look at it. Everything that we're talking about, Your Honor, let me just, and I would like to submit this in camera if you don't mind, because it is sensitive from the U.S. Justice Department. The U.S. Justice Department has.
Objection. Before, I would object that if Mr. Underwood is going to attempt to introduce or make reference to any memorandum from the Department of Justice that he has already made reference to in his suit in Fulton, that we have an opportunity to see that, to see whether there's any objection. I have serious questions about that document or documents, and I'd like an opportunity to look at it and not simply just say, let's go take a look at it in camera. But
Are you
it's also direct.
Well, if I could ask for an objection. So, Mr. Underwood, you started talking about something, but you hadn't tendered anything or identified anything. Are you planning to try to introduce something now?
No, not at this time, but I will probably do it after the respondents.
And let me ask you also, the nature of this calendar is it's one route for cases to get to a prosecutor's office for
Yes.
consideration, where they ultimately say yes or no.
Yes,
And then they have the burden of proof.
yes,
And so, part of your warrant application was whether law enforcement had been contacted. did you go to any law enforcement agency?
In Fulton County?
These issues, yeah, that you're alleging today?
Not at that time, Your Honor, not in Fulton County, no.
Okay, and so until I hear otherwise, I don't know that law enforcement, anything that they looked into in regards to these allegations, until you show me how it's relevant.
Sure.
If you're saying I've been wrong, this is the forum today, you're a witness, subject to cross-examination, you have the burden of proof, but I would need to understand how other law enforcement investigations are relevant to this. At this point, I think it's premature to sustain an objection but I think that's where this is going.
Sure. No, I understand, Your Honor. The crux of all these individuals, Your Honor, is when so let me just continue. After they canceled my Georgia, or after the Secretary of State canceled my trademark, I subsequently sent letters to GoDaddy, the GoDaddy CEO, Aman Bhutani, and also the Bank of America CEO, Brian Moynihan, outlining with evidence, Your Honor, including the transcript that we've discussed. And counsel is fully aware of these emails and letters that I sent to the CEOs. I was met by harassment, intimidation, and threats from Bank of America and their counsel to essentially keep quiet about this, Your Honor. And I think that's a very fair characterization of it, because we got letters from when I sent those letters to Bank of America CEO and the CEO of GoDaddy. I was getting threats from all the attorneys who were involved in this conspiracy, Your Honor, which also goes to the RICO statute of threats and intimidation, Your Honor. And so we went from there.
Okay. Anything else?
I'll reserve my time.
Thank you. And for respondents counsel, for either group of respondents, do you have any questions on cross?
I do, but I'm not exactly sure what Mr. Underwood means by I'll reserve my time. He gets to testify once. So I would ask that he complete whatever it is that he is going to testify about, unless he wants to do redirect of himself afterwards.
Well, I'm leaving it at that. So you are entitled to some redirect, which would be limited by what's brought up on cross-examination. And then if you say something on redirect, then the other side could ask questions on recross. And I guess it could go back and forth a couple of times that way. But at this point, if there's anything else that you want to say that's relevant to your warrant application against these 16 people, please tell me now.
Yes.
If not, then you're subject to cross-examination. Then you can give argument at the end, certainly to point me to reasonable inferences based on the evidence.
Sure.
So it sounds like there is there anything else new that you want to tell me?
Yeah, GoDaddy had no right to access my records. They had no subpoena. They had no.
Sorry to stop you.
Yeah.
You seem to be arguing. You'll have.
Oh, I'm sorry. What I would say is, since you have the case number in Judge Edwards' courtroom, the declaration is in the exhibits.
Okay, and are you saying that you want me to look at that?
Yes, sir, and I can.
Okay, is there any objection to that? I've been referenced.
Same objection, Your Honor, that the complaint that was filed in the Georgia Fulton Superior Court matter contains various references to documents that were all they're all part of the same protective order from the Colorado litigation.
And Your Honor, we would just make objections on the basis of relevance, that we haven't been provided with a copy of this exhibit, and to the layers of hearsay.
Okay, so what I intend to do but I'll give you the final word on it too.
Sure.
Is that I'm going to take it under advisement like I did before, waiting to hear the relevance. So, you can put it in reference to the rest of the case. And then if there is a relevant connection, then I'll consider the underlying objection, but I'm not there yet until it's relevant, until you tie it together. All I'm doing now is you are offering it. And so it's something that I will consider.
Sure.
But right now I'm trying to figure out procedurally where we are in the case. Any other testimony or documents or anything that you want to present in your case in chief?
I do. In her declaration, I like to proffer, Your Honor, and I'll be happy to show this to counsel. Miss Willis lied about me having no receipts of hosting, which is very relevant because it goes to the date, Your Honor, that she knowingly fictitiously put in there in the conspiracy with these other individuals. And these I will proffer as evidence as GoDaddy receipts, Your Honor.
Okay, can you show those to opposing counsel through the marshal?
Yes, sir. Oh, yes, ma'am.
Thank you, Your Honor. I have just a couple of objections, which is both the authenticity and foundation. I don't have an indication of where these came from or what their source is. One of the documents appears to have a document from the 10th Circuit, one page from the 10th Circuit case attached to it. And so on those bases, we would object to these documents being considered or admitted.
Okay, if you could pass those back to Mr. Underwood. Let me just make the record. So this has been marked as A2. And so, Mr. Underwood, what is it?
These are hosting receipts from GoDaddy, Your Honor. And I will testify to the validity of these documents. These are hosting receipts that are the subject within her declaration, Your Honor, that she said that I never had.
Right.
And here
They're objecting to their authenticity.
these are, counsel full well knows that these are receipts from GoDaddy, and these are printed receipts from GoDaddy themselves, Your Honor. It was downloaded.
Let me just ask, if you're objecting to these, I think it's back on you to say what's missing from the foundation.
I would like Mr. Underwood to proffer where they came from. Are they something that Mr. Underwood printed off of his email? I'm not sure where these documents came from. And then one page shouldn't be included in there as well.
Okay. So I need to understand the authenticity.
Sure. These were originally downloaded by me from GoDaddy's website, Your Honor, where under the history of billing and products, you can go there, Your Honor, and download any receipt that you purchased any product from in your history, Your Honor.
Okay. Any response just on the authenticity issue?
No, if it's Mr. Underwood's testimony that he accessed his customer account and printed off copies of those receipts, and those are the documents that he printed off, then we would withdraw our objection on authenticity.
So I'm still a couple steps removed from considering the contents of anything because I still have to understand the relevance. But in terms of authenticity, I do find that you've met your burden.
Yes, sir.
And so I just need to hear the relevance part later.
Yeah, sure.
Is there anything else you want to say before you're asked questions in the cross?
No. What I would say is, Your Honor, since you're taking it under advisement, it's Ms. Willis's declaration is Exhibit N in Judge Edwards' courtroom, and it's under the notice of filings. And you will find this very relevant, Your Honor. And if I may, when Your Honor is ready, once I give the other side their chance, I'd like to revisit that date and also in conjunction with the deposition, because the receipts and the deposition, Your Honor, go hand in hand for the declaration for Ms. Keena Willis, which ties everyone together all 16 people, Your Honor.
And Your Honor, I would just note that to the extent that these receipts were exhibits to the declaration or to the deposition transcript of Ms. Willis, that they also would be subject to the protective order.
Your Honor, Your Honor, the deposition itself is not under protective order. I do acknowledge, however, that what's under protective order, and Your Honor, she wasn't, the counsel wasn't even a party of the Colorado, so she doesn't know the protective order like I do. And I know for a fact that the protective order protects documents that we received from Bank of America, not anything else. That it was a production order, Your Honor. And for instance, Your Honor, Keena Willis doesn't work at Bank of America, is not an employee of Bank of America, and therefore this has not been produced by Bank of America.
We're going to move on at this point. I'm taking it under advisement, and I have to hear relevance before I get to these other issues.
Sure.
Is there anything else from the applicant?
No, Your Honor.
Okay.
Not at this time.
Okay. So any cross of the applicant?
So before we have a cross, this is a little unusual, Judge, but this is a criminal proceeding. You'd move for a directed verdict, an order from the court. Mr. Underwood has provided no evidence that any crime was committed by the 11 respondents that I represent. There has been no evidence that any crime was committed, period, other than some sweeping accusation that they conspired, they were jerking us around, they schemed in a conspiracy. What he suggested to the court is that this deposition somehow was masterminded by some people without any specificity. That's not evidence. And so I'd ask before we even need to cross-examine him, the court directive, if there is such a thing, finding that he has not met his burden of proof as to the crimes that he alleged in his May 1st, 2024 application for warrant against the 11 respondents that I represent.
And Your Honor, we would join Mr. Brickman's motion on behalf of the 5 respondents that we represent.
Okay. And let me just digest that because there is no such thing at this stage. But if I understand what you're saying, the gist of a directed verdict in that situation would be, you know, the language is if you look at the evidence in the light most favorable to the applicant in this situation, you know, is there, you know, any issue for the finder of fact? And the idea would be that, you know, they're saying, Mr. Underwood, that your case is maybe here, but it needs to be there. You know, there is probable cause, and it's somewhere between no scintilla and PC. It's somewhere below where it needs to be. And after a thorough and sifting cross, it's not going to get better for you. If anything, it's just going to stay where it is, or maybe be eroded a little or a lot. That's kind of what you're saying is this is as good as it's going to get, and it's not enough.
If that's as good as it's going to get for Mr. Underwood, in the light most favorable to Mr. Underwood, there is no evidence that a crime was committed. And I would, excuse me for a second. And we're not saying that it's here and it's going to get to there. It's gone nowhere. There is no evidence, period, credible evidence that any crime was committed by any of the respondents at all on August the 19th, 2019 at the Georgia Secretary of State's office. If the court...
I'm ready to rule.
Okay.
And so if you could have a seat, Mr. Underwood. Given what this, you know, the counter that what you chose, where you chose to bring this case, I'm gonna again just say there's not really anything for me to rule on. If respondent has any questions of the witness, you can ask them questions now. And then after all the evidence is closed, I'll rule where the applicant has the burden of proof. But I don't want to get into this gray area of pre-ruling. Just when all the evidence is closed,
Okay.
I'll rule. I'll keep an open mind until then. I don't adopt anything that either party has said about how strong it is. If you have any questions, go ahead and ask them now.
We're ready.
Thank you.
Does the court mind if, well, think I'll just slide it back. It's a little.
Whatever, however you want to do it, we can move the podium around. This is y'all's courtroom, not mine. So go
It's
ahead.
more your courtroom than it's my courtroom.
Yes, well, we are here a lot, but that's okay. We work for you. All of you.
Mr. Underwood, on May the 1st, 2024, you appeared in Fulton Clerk of Court. Did you not?
Can you repeat that date?
Yes. On the day that you filed these warrant applications, did you appear in front of the clerk at the clerk's office in Fulton County?
I did.
Okay. And you were given a form to fill out, were you not?
I did.
These were warrant application forms, correct?
That's correct.
And you were asked to provide them with the basis for which you believe my 11 clients committed a crime in the state of Georgia.
Yes.
And you testified, would you like me to stand your own?
No.
Okay. Sorry about that. Judge Wolf asked.
As long as the witness can hear and see you, I mean, y'all are right next to each other. Whatever works for both sides.
Thank you very much. Judge Wolf asked you this morning to confirm that what you presented and what you swore to in Fulton County Clerk of Court was the truth.
Yes.
And you testified to that day, you actually signed a form saying that you swear that the information that you provided is true.
We cleaned up the date, if that's what you're getting at.
I'm not getting at that. I'm getting at, did you swear that what you put down, I'm going to give you a pass on the date. Okay. So other than the fact that you got the wrong date.
Yeah.
Everything that you put in that form that you wrote in those 3 lines that you wrote, you're saying is the truth.
Yes.
Every box you checked was the truth.
It was the truth.
Okay. So as an example, just a few minutes ago, you started to make reference to you getting law enforcement involved. Do you remember that?
Yes.
Okay. Now, do you have a copy of these 16 warrants that you're trying to have issued by Judge Wolf? Do you have it with you?
I believe we do, yes.
Great. Why don't you take those out for just a second, because I want to show something to you.
Sure.
Okay?
Thank you.
I just printed them.
Oh, those are the ones.
Yep. Did I see the other stuff?
I don't need these. Okay, Mr. Brickman.
Great. Okay. So on each of these forms, because they're identical forms, if you look, you see where it says in the third, I'll call it third section, that's called incident information. You see that?
Yes.
Okay.
I
And
do
so
see
the date of the incident, you said was August the 2nd of 19. Today you said you meant the 19th, right?
Yes.
Okay. And,
Yes.
and what you were saying there when you swore that everything you were saying was the truth is that it is your contention that on August the 19th of 2019, but when I'm saying my clients, because now you know who I represent and who I don't, my clients committed a crime in Fulton County, right?
Yes.
Okay. And you're saying that the crime scene, sort of paraphrase it,
Sure.
where this crime happened that you say they committed was at the Secretary of State's office down the street.
Yes, they submitted documents, they submitted and paid for the judge's order, and they submitted a cancellation fee, and I believe that was one of your clients.
Okay, and so let's back up for a second, because the cancellation was ordered by the court in Colorado, was it not?
It was ordered by the court in Colorado, and your client was involved in a conspiracy.
Okay, so I want to hone in on this a little bit, because at the beginning of this hearing, you started off by telling Judge Wolf, my trademark was canceled by Bank of America. You remember telling him that?
Yes.
Okay, the judge in Colorado entered an order after having this legal proceeding that lasted 6 years and ordered because the court did not find in your favor, the court ordered that the Georgia Secretary of State cancel the registration. That was part of the order, wasn't it?
So you're getting into semantics. What Bank of America countersued to cancel my trademark.
Okay.
I am going to ask you, Mr. Underwood, if you're asked a yes, no question,
Okay.
at least please start your answer with yes or no, or I don't know. And then you definitely can explain your answer.
Sure. Okay.
But I need, because what Mr. Brickman says is not evidence, but what you say is.
Sure,
So I-
understood.
That will help me.
Okay.
Yes, Your Honor.
When your case was over in Colorado, the court ordered that your trademark that you filed in 2010 be canceled
Yes, that,
by the Secretary of State of Georgia.
signed the order, or that ultimately took it out of the registry?
Yeah.
Yes,
the
by
order
the
was that-
Secretary.
Right, so the Secretary of State, you agree, has the authority to do that if it has a court order, which it did.
If defendants are engaged in racketeering or criminal conspiracy, Georgia law forbids anyone from receiving anything directly or indirectly illicit, from illicit activity.
Okay, that's a good definition.
Yes,
That's not what I asked you.
but that's what
Okay,
happened.
and listen to the question.
Yes,
The Georgia Secretary of State dismissed your registration at the order of a court in Colorado, did they not? That's an easy question. Yes or no, they did or they didn't?
it's what ultimately happened.
Okay, it's what ultimately happened. Okay, let's go back to your application forms. Because after you put down on each and every one of these applications that the crime occurred at the Secretary of State's office, you're given some room to explain what crime or crimes you believe were committed, right?
You get very little room.
Okay, nobody told you, you came by yourself, did you not?
I did come by myself.
Okay, you've graduated from college, right?
Yeah.
Okay.
Law school dropout.
May not have been the worst decision you ever made, but you graduated from college, correct?
Yes, that's correct.
You
yes.
hired counsel in Colorado and they represented you quite well for several years, did they not?
They represented me.
Okay. And you decided to come down here by yourself and come to the clerk's office and fill out this warrant application.
With their knowledge.
Okay.
With their knowledge.
All right, and this is your handwriting on each of these, is it not?
It is mine.
Okay. So you decided to file this application and no one told you that you only had a certain amount of room to explain what it is you believe the crimes were you?
You cannot attach anything to, I don't know if you ever filled out one of these on behalf of a client, Mr. Brickman, and I wanted to attach more documents to explain the entirety of it. I was told by Miss Mary, who works in the warrant division, that you cannot attach. I have been through this. Trust me, I would have attached a boatload of evidence if I could have. But what is it contained in the four corners is what I could only express in a limited space.
And
Please
so-
ask your next question.
Thank you. So after your brief description of the crime that you believe was committed, you were asked, did you contact police? And there is a line for no, there's a line for yes. And if the answer is yes, then you were asked to put the agency and the case number. Do you see that now? Right below the three lines that you describe what crime you believe my clients committed.
What box? Oh, yes. Did you, yeah, I see it right underneath the description.
Okay.
Did you contact police?
Right. So
Police. Yes.
correct. So you said at the beginning when we were just meeting Judge Wolf that you used to work for Mr. Carter.
Yeah.
Okay.
police, yeah.
So law enforcement is law enforcement, right?
It says police.
Police. That's correct.
Police.
Right. Okay. And so when you said no on just about every one of these, you said you were telling the truth that you didn't contact law enforcement?
I didn't contact an Atlanta police officer or a detective. I did not contact the Fulton County Sheriff's Department at the time.
It didn't ask you Fulton County. It said, did you contact
The
police?
police. Then that's a no. It's a no.
And what you're suggesting to Judge Wolf is that when you thought police, you're only referring to the Fulton County Police or the Fulton County Sheriff's Office, not any other law enforcement agency in the United States of America.
This is a Fulton County document.
Didn't ask you that though. It asked, did you contact police? And you said no.
Let the witness answer the question.
The police, well, as I understand it, and you know, I'm educated to know that police is police powers here in the state of Georgia, because this because I don't have the specific statute for the warrant or the warrant applications, but it's, it allows people to do that. And so here we are.
So you mentioned that you would have liked to have introduced, as you said, boatloads of evidence and attach it to it.
Mhm.
You had not had this case presented to any prosecutor here, did you? You?
Not at the time,
Okay, well,
not in Fulton County, no. But that has changed since then, I can tell
Okay.
you that.
all right. And so,
And there is, and just so we're, since you're asking me the question, I want to answer it, about the police. They have started an investigation here in Fulton County that I can proffer to the court today.
okay. So,
I'm sorry, I have to interrupt. So, Mr. Underwood, you say that there is an ongoing criminal investigation in Fulton County that relates to these same allegations?
Yes, sir. It just started not too long ago, but it happened after.
Do you have a case number?
I do not. I know that the investigators who are working on it.
With which department?
It's actually the Fulton County Sheriff's Department, and I believe DA Fonnie Willis is also looking into it as well.
The reason why I ask, and I just want to pause things for a moment.
Sure.
I tried to kind of show this earlier, that just as, I don't know, if you're leaving the courthouse, I'm trying to think somewhere that everybody could agree on, maybe to, I don't know, Truist Park. Braves are playing a little better now at the All-Star break. There are at least 3 or 4 different ways to get to Truist Park from here.
Sure.
And so similarly, there are 3 or 4 different ways for a criminal case to get to the DA's office. But ultimately, it's their call whether they move forward with a case or not. So when I hear that there is a sheriff's department pending investigation, what I hear is that you want them to be thorough, and you respect their decision on what they find, correct?
Absolutely, Your Honor.
And ultimately, you realize that you have to put your trust in the DA's office, how they respond to that investigation. It's ultimately their decision and their burden in a criminal case, correct?
Yes, sir. I think they got involved after they saw the filing with Judge Edwards.
I get where this case and your livelihood has been on hold for a long, long time.
Yes, sir.
And you had every right to pursue this criminal warrant application process. That's why we're here today.
Yes, sir.
And I'm willing to see it through today, but this is a wrinkle. And the reason why I say it's a wrinkle is, what if I make a decision based on what's presented in front of me today, and then the sheriff's department and or the DA's office do something different? They have resources that I don't have. They also, in general, I'm trying to say this diplomatically, they are seeking justice, but they are part of law enforcement. Law enforcement can have a candid conversation with them.
Yes.
Whereas somebody like me as a judge, I'm neutral. I'm not on your side and I'm not on their side. So I'm really inclined to table this completely today and let them complete their thorough investigation, because that's the best ends of justice. Now, the way that would look is that I would dismiss your warrant applications because there's a pending investigation, not on the merits. I wouldn't get to the point of saying that you've met your burden or not.
Sure.
But what do you say about that?
Your Honor, first and foremost, I appreciate your thoughtfulness in this. I really do. And I really appreciate that, this has taken a lot of time out of my life, because I'm fighting for justice and I'm fighting for something that was taken away from me. And on Friday, if Judge Edwards sees it that way, I can get it back. And I really do believe in justice and the laws of our country and also due process. And I think what you're getting at is due process for everybody, including the respondents and pending the investigation that's going on. It's I hear what you're saying, and I think it makes sense.
Okay.
And I do have faith in the evidence, and I have faith in the sheriff's department, and I have faith in DA Willis that they're going to come to the same conclusion that the DOJ has already come to, and which there have multiple agencies on the federal side investigating, which I'm privy to.
Okay.
Your Honor, before it,
I was going to ask if, anything else I should consider.
well, I would like permission to follow up on this particular issue about law enforcement and when they were advised. Because the fact that Mr. Underwood is asserting that there is an investigation underway by the Fulton Sheriff's Office, which may very well, can I question a little bit further as to when that investigation began? I thought he just told you that it happened once they learned of this suit that he filed that's going to be heard before Judge Edwards at the end of the week.
Well,
Because that's what he told you, but I want to make sure that that is in fact what it is, because
is the question for my purposes, and I hope that I've made myself clear in my neutral spot, where if I don't want to get in the way of an investigation and a charging decision by a prosecutor, since that appears to be moving forward, as long as everybody is in agreement that that is the situation, then that's what I'm going to do. If there's some question as to whether that really is the case, then, maybe I would. So in other words, I'm not so interested in when something started, but just to make sure that there is something pending right now.
that's why I'd like to ask the questions, because all we know right now is Mr. Underwood said, if I got it right, that that an investigation has begun, that he's mentioned the Fulton Sheriff's Department, he's thrown out Fonnie Willis's name, and he said they probably got involved after the suit was filed, probably got involved. So I'd like to know how does he know an investigation began? When, which law enforcement agency, and what do we know for sure that it has begun?
Okay.
Just saying it.
And please don't say anything if y'all can both have a seat. So the short answer is I'm going to go ahead and make a ruling, and I'm not going to allow that question. I do think you might have noticed what I really try to do, and on a good day, I'm effective at this, is not just to rule, but explain why I'm ruling a certain way. Y'all deserve that. This is a warrant application that you chose to take out. And I'm reading between the lines a little bit here to say that you took out this warrant application because you were fed up, your life's been on hold, this patent, everything about it is, the Erica is, to some extent, it's been your life's work.
Yes, sir.
And I can appreciate that. And I also very much appreciate everybody from GoDaddy and Bank of America and everybody else. They take a lot of pride in the work that they're trying to do and the interests they're trying to protect. The bottom line is, I find that you took out this warrant application, you had your reasons at the time, and as of today, now, finally, in your opinion, I'm not judging that.
Sure.
It's not my place to say, but now that law enforcement is looking into it, according to you, you want to go that route, not this route. That's your call. The respondent is responding to an application. And so at this point, because there is an ongoing investigation, I'm dismissing the warrant application. I see it as, if the Sheriff's Department had been on this earlier, you very well might not have taken out this application in the first place.
That's correct, Your Honor.
And so with that, if, Mr. Brickman, I try to look ahead and say, okay, I think I know the 4 or 5 questions that you would ask. And regardless of the answer to those questions, I still land in the same spot. And so that's why I hope both sides understand. I'm going to, again, I'm dismissing all 16 warrant applications because there is an ongoing investigation, and that does not preclude anything that happens with Judge Edwards on Friday.
Right,
That's separate.
right.
And that doesn't, I'm not instructing the sheriff's department or the DA's office, you know, and Fonnie Willis what they do. So that's kind of where we are. Is there anything else I need to take up at this time?
Your Honor, may I just make a note for the record?
Yes.
Given Your Honor's ruling, which we understand and of course will abide by, that GoDaddy, excuse me, that we on behalf of the respondents we represent, were not given an opportunity to cross-examine Mr. Underwood, and we just wanted to put that on the record for today. And I guess just note for Your Honor's consideration that our concern that we may end up right back here if the whatever investigation that we have no knowledge of doesn't conclude to Mr. Underwood's satisfaction. We certainly don't want Mr. Underwood to then be able to have an entirely new warrant application process where we would have a second chance to sort of go through this whole process again.
Well, let me just say this, and you can have a seat. Thank you. As far as my orders, they're going to be a little detailed as far as why this is being dismissed. And really, Mr. Underwood, to capture the spirit of what you said, that whatever path, you know, in other words, the train's kind of leaving the station on the warrant application, getting the case to the DA's office. The sheriff's department is looking into this, according to you.
Yes.
And the DA's office can decide whether they want to move forward, and if so, what the charges would be. And then they would have an obligation to you under the Victims' Bill of Rights to keep you in the loop, but it would be their call. And so I'm not precluding anybody from applying for a warrant, but it would be clear as day on my order from today that, again, the train's left the warrant application station, and it's, if it gets to the DA's office, great. If it doesn't get to the DA's office, great. I'm not pulling for one side or the other at all, but that would be the route. It's kind of the end of this route. And so, Mr. Moynihan, that's how I respond to you. I do have a question for you because I didn't really clarify this for the record earlier. Mr. Brickman, he made I'll use my air quotes, directed verdict motion earlier. Were you adopting that earlier, or were you staying out of that argument?
Your Honor, I was joining Mr. Brickman's argument.
Okay, that's what I thought. And so to that extent, I find that, you know, you just made it part of the record. There's really nothing for me to rule on. But I think that you also wanted me to rule based on what I had heard, and you were willing to forego cross-examination for me to go ahead and rule in that moment. You know, that's the way I took it. Anything else from, I know Mr. Brickman desperately wants to say something.
I do, and I.
Snatch defeat from the jaws of.
No, I'm not objecting to the court dismissing the applications. I'm not. And before we leave the warrant application station, of course, mentioned it, would the court consider, in addition, as an additional reason why, is that based on the evidence presented so far that the court is dismissing, hold on, Mr. Underwood, you'll have your chance.
I'm sorry, you don't have to direct other people what to do. He's a grown man. I would ask, though, out of respect to both of you, please have a seat. I'll give you a chance to respond for sure.
I understand that Mr. Underwood has advised the court or testified to the court that there is now criminal investigation that's been initiated by the Fulton County Sheriff's Office, and mentioned Ms. Wills's name as well. Our argument is that while that might be true, as of today, after his presentation of evidence, our position is that he failed to meet his burden at his warrant application hearing. And the fact that if there is no evidence that he has presented that meets probable cause standard, that doesn't mean that if the Fulton County Sheriff's Office, for whatever reason, if they in fact have initiated investigation, determine that a crime or other crimes have been committed, that they can't do what they would ordinarily do, and the DA's office could do that too. It's just that I would ask the court to consider adding that as an additional reason in support of its order today that it's dismissing the applications.
And also, you know, to add to that, you know, I'm looking at a jury box. Ultimately, if they did decide to go forward with something, regardless of what I do today or not, they have to convince 12 people unanimously beyond a reasonable doubt if they choose to go forward with something. And again, defendants never have to prove their innocence or prove anything or present anything at this stage or down the road. Mr. Brickman, I didn't mean to cut you off though. Was there anything else?
I mean, I don't mean to be much levity about this. We've talked a lot about how difficult this has been on Mr. Underwood, and this is his life. He's gone to the clerk of court and sworn under oath that 11 individuals have committed crimes. Our position is that those are false accusations. And while, you know, everybody comes into court today with their own life's experiences, what we've got here, this is none too subtle. There's nothing worse than being accused of a crime you didn't commit. And so right now, he's had his opportunity today to present his evidence.
I understand.
And I'd ask the court to also dismiss the case based on his failure to meet his burden in his warrant application hearing.
Sir, you can have a seat.
Okay.
I'm not going to do that.
Okay,
And I mean, if you insist on saying something, I'm never going to cut anybody off.
sure.
But the spirit of my ruling is to let this investigation unfold.
Yes, sir.
And,
Thank you, Your
and
Honor.
I want the sheriff's department or the DA's office to be unfettered by anything that I might do or not do here today. So I am dismissing it on a procedural basis, not getting to the essence of it. And I'm not going to say, oh, I was this close or that close. You know, let the sheriff's department do their work. Let the DA make its charging decision. Let the jury do its due diligence. Wherever this case may go, my order won't go. It's not going to go that far.
All right, thank you.
You're welcome. Is there anything else?
No, Your Honor, I appreciate it.
Okay, thank you. And so if, I will leave it at that. And Ms. McMullen, anything else that you need to know? Okay, so everybody's excused. I am going to ask y'all to kind of follow the marshal's instructions on leaving. It might be better for everybody to kind of leave separately. I did want to just tell Mr. Monhai safe travels. I didn't get to ask earlier. I don't think I looked up. Where in Pennsylvania are you from?
I am in Philadelphia and I am a Phillies fan.
Okay, better that we know that now.
Your
Yeah,
Honor.
I'm glad we held up.
So much for that phone invite.
Yeah,
Prematurely
papers.
granted.
Okay,
We could
so we have
copy
a
the order.
Phillies fan and Florida Gator, so
Yes.
there you go.
And Your Honor,
A
thank
copy
you.
of the order, please. Or who should we contact to get a copy of whatever the dismissal?
You know, I've got a hard copy that I will fill out
Okay.
today and file. It'll be available electronically. Ms. McMullen, you say later today? Right,
I will say probably.
No
yeah,
problem. Thank you very much.
maybe tomorrow.
Thank you.
Thank you all. Everybody have a nice day. Be
Thank
safe.
you.
Thank you, Your
Whatever
Honor.
happens with the myriad of cases, good luck to everybody.
Thank you.
And to our audience, y'all are excused. Well, nice to see everybody. Did we want, before y'all go, we had this hard copy was that from Mr. Underwood? You want that back? Or was that ours?
That's for
That's
you.
from the clerk's office. Okay. We're good to go then. Thank you.
Okay, we'll stick on.
Okay. Comes off.
That's it. It's done.
And that. All right. So let me, we still have control services.
I don't think there's anybody here that was taking it in. She's not a quote for it.
I don't see a pretrial.
That's fine.
Okay, so pretrial services is not here. I was just gonna tell them they're excused till 1. And Mr. Tay, if you're there, we're in recess And we can stop the recording, please. All right, so it is 1 o'clock. Are we recording?
We are live.
Great, thank you both. All right, so again, good afternoon. I'm Judge Wolf. This is our warrant application calendar for Monday, July 15th, 2024, courtroom 2C, 1 o'clock. When you hear your name, if you're physically able, please stand. Just briefly so that we can see that you're here. Number 1, 24 MAGC 02395, Shakia Allen and William Harris. No answer. 2, ending in 2376, James Benson. No answer. Latrina Powell. No answer. 3, ending in 2260, David Bernstein. This is part of the case from this morning. I think number 3 is on an error, but I'll just put a question mark. Number 4, ending in 2389, Tavolsia Brooks.
Good afternoon, Judge. Good to see you. Chad
Yeah.
Bassett here.
Yeah.
We're present. Mr. Brooks is here. There's a co-defendant on the case as well. My understanding is Pullman, the individual that filed, is going to be here, or he's here. If I could just talk to him briefly, because I think this is something that would be worked out, at least for my client.
Okay. Let me just check everybody in for now. We do have a mediator who can also talk to both sides. And so let me just check you in for now, but Chris Pullman's not here yet. You are here. And Tavolsia Brooks also?
He's present. He's raised his hand.
Great. Yeah, if y'all want to just talk amongst yourselves, give me a second though before you do that. I just want to make a, can you wait just a, yeah. Let me just say this, particularly to Tavolsia Brooks. Where's Tavolsia Brooks? There you are. Sir, I just wanted to say that you are the respondent, so you are a potential criminal defendant. So you don't have to say anything. You don't have any burden of proof. If you want to talk privately and just it's something that y'all can resolve, certainly you could be a part of that conversation, but I just want you to understand your constitutional rights. Counsel often represents people charged, so I think he, can navigate through that process, but I just want to make sure your rights are protected. Okay, so y'all can go out and talk. Thank you. Number 5, ending in 2373, Jawan Buggs. No answer. William Harris. No answer. 6, ending in 2375, Neva or Neva Calhoun. No answer. Jessica Turner. You are here. Thank you. 7, ending in 2372, Sarah Gacobo. No answer. William Harris. No answer. 8, ending in 2391, Nigel Morgan. No answer. Ariel Mack. No answer. 9, ending in 1228, Diego Ortiz. No answer. Lashunda Lovelace. Good afternoon. Nice to see you. Number 10, ending in 2396, Elizabeth Ortiz. No answer. William Harris. No answer. 11, ending in 2393, Ira Richardson. No answer. Mark Williams. Thank you, sir. Number 12, ending in 7033, Demetria Tillman. No answer. Adetayo Tiamiu. No answer. 13, ending in 2390, Lemarian Weems. You're here. Thank you. Chris Pullman is, just a moment. Okay, so Chris Pullman is also on position 4. And so Mr. Weems, where's Mr. Weems? I don't know if you heard what I was saying to the lawyer on the other case with Tavolsia Brooks, but you might want to be part of that conversation. I don't know. The thing that I want to make sure everybody who's a respondent understands that you do have the right to remain silent. You don't have to say anything. You don't have to prove anything in your role. If you want to just wait in court, when they come back, we can have a conversation. Thank you. Number 14, ending in 2371, Zaquay Willis. No answer. William Harris, no answer. 15, ending in 388, Frederick Wright. No answer. Ken Mullins. No answer. 16, ending in 2392, Shida or Shida Yang. You're here. Thank you. And Tatanisha Hastings. You are here. Thank you. Did I miss anybody? Is there anybody who thought you would hear your name called? Yes, sir. Okay, I remember your name. Hold on. Which one?
Position 8.
8, thanks. You're Nigel Morgan. Thank you. And Ariel Mack is not here. Is there anybody else? Okay, so that does complete the calendar call. What I'd like to do next is just talk briefly about this calendar, what kind of calendar this is, because every type calendar is a little bit different. This is a criminal warrant application calendar. So it is a criminal calendar and it's not a civil calendar. With it being criminal, if you're the applicant, you have the burden of proof and you have to prove your case by probable cause, which means that a crime probably happened. If you prevail, if you meet your burden of proof, being probable cause, then the case will go to a prosecutor and the prosecutor could decide what to do with the case next. They would have the burden of proof. Similarly, if I say there's not enough probable cause to move forward, there are ways that a prosecutor could still go forward with the case anyway. But that's the issue if you are the applicant. Now, if you are the respondent, because you're responding to the application is being offered against you. Like I just mentioned, you have the right to remain silent. You don't have to present any evidence and you have no burden of proof. So just please keep that in mind. When both sides of the case are here, we are going to send you to our mediator. And that's in most situations. The reason for that is to give both opportunities to empower really both parties to work something out if you can. Once you're in mediation, actually agreeing to something is up to you and it's voluntary. So once you're in mediation, don't feel like you have to agree to anything. If you can't or you choose not to work something out, then I'll hear the case today. But like I said at the top, the applicant has the burden of proof. And if you do prevail, somebody else is going to make the ultimate decision on whether the case goes forward and how so. That's going to be the prosecutor. I am going to give the other side of your case till 1:30 to get here. So if you see that they're not here yet, I'm still going to give them another 20 minutes. Let me just look at the calendar here for a moment. Mr. Young, on position 3, ending in 2260, I just want to pull up. That was also 2260 was position 3 on the 9 o'clock calendar. And it was handled then. So we're going to take position 4 off the calendar. I'm sorry? Position 3. I said 4, I meant to say 3. Hold on one second. Yeah, that was my mistake. Yes.
Position 14, last name release easier.
Hold on. So on position 14? Okay. So is Zaquay Willis? Yes. How do you say your first name? Zaquay. Good. I wanted to make sure I got it right. Good afternoon, Mr. Willis. I'm going to give the other side of your case about 15, 20 minutes to get here, and then we'll take it up. Thank you. Anybody else? Okay. So let me just look for a moment.
Manage, you have on the on silent, please.
Mr. Young, can I ask you, is Miss Lovelace, is she one of the rental car company people? No, I didn't think so, but she's, yeah, just double check. Thanks. There were a couple of them. That's the only reason why I asked. It was number 9 and I bet there was another one. No. I'm sorry. Right. But it's not a rental. Yeah, if you could just double check. I do want to ask about position 16, 24 MAGC 02392 with Ms. Hastings and Shida Yang. So Ms. Hastings, are y'all proceeding on that case? Okay. If y'all could talk to the mediator on position 16. We'll put number 16 down for mediation. Okay, thanks. And also, Mr. Young, what date were notices sent out? June 12th? Okay.
No change in the notices.
Okay, thank you. Could I see number 4 for a second? And also $13. Thanks. Yeah. Mr. Young, do you know the lawyer's name on that case that walked outside? It was on number 4. Yeah, I was just curious. Okay, so we'll hold on those. You can take a pat. Thanks. Which one? 12. Thanks. Adatayo. So on position, thank you, position 12, 7033, Adatayo Tiamiu is here. Is that right? Thank you, sir. All right, the other side, Demetria Tillman is not here. I'm going to give them till 1:30 to get here, and then we'll talk about your case. Another 12 minutes or so. Thank you. The other respondent is here as well.
Yes, Your Honor, I spoke with him as well.
Okay.
I think we should be able to resolve this with a mediator or other individual, and he may exonerate.
Okay, I'll give you a chance for everybody to talk to the mediator. Is there a mediator here? She's back there.
Yeah, apparently she's with somebody.
Okay.
So one stay and withdraw.
Do you have other court you need to be on?
No, this is it.
Okay.
I had to bring my son to court in the back, so if you see that little in the back, he's mine.
I was wondering, your star witness?
Yeah, sorry with this.
Good deal. Thank you.
Yeah.
Six. Excuse me. Thank you. Yeah. Okay. Hold on. Got it. So on one like that, we're okay if they've got it now. Right. Yeah. Got it. Thanks. Oh, I know. I appreciate that.
Please put your phones on silent. Smart wireless.
All right, so it is 1:30 exactly. We're gonna pick up where we left off. So notices were all mailed out June 12th, 2024, no return mail or change of address filed. So at this point at 1:30, everybody got good notice. I want to thank y'all for being here. We're going to move forward with everything. I'm just going to go straight down the calendar. Position 1, ending in 2395, Shakia Allen and William Harris. They're not here. No return mail or change of address. That application is dismissed for want of prosecution, DWAP. Number 2, ending in 2376, James Benson and Latrina Powell. They're not here either. Good notice, DWAP. Number 3, ending in 2260, was number 3 on this morning's calendar. It was handled then. We had a hearing. Number 4, we're holding. That is Tavolsia Brooks and Chris Pullman. I'm sorry, Poland. Number 5, ending in 2373, Jawan Buggs and William Harris aren't here at 1:30 DWAP. Number 6, 2375, if Jessica Turner, could you come forward, please? And Neva Calhoun is not here at 1:30, got good notice. Good afternoon. We're going to swear you in first. If you could come up, stand up at the podium, please.
Yes, I do. Jessica Turner.
Good afternoon.
Good afternoon.
So I'm looking at your warrant application. You don't have a date of birth for Neva Calhoun.
Correct.
Do you know that now?
No.
You don't have it? That's an issue. Let's
Okay.
just say that I find that you prove your case for today's purposes, and I'm ready to sign a warrant. I can't sign a warrant without the birth date.
I understand, Your Honor.
About the only thing I can do is either just dismiss your application, and then if you wanted to go forward later, you could, you might have options, or I could reset it one time for you to get the DOB.
Okay,
Or do you want to move forward?
I'm okay with resetting it. But the thing is, I have asked Atlanta Police for assistance because she refuses to give it to me. The leasing office refuses to give it to me. She's a stranger to me. So
Thinking if it gets reset, what's going to change?
yeah. But
tried to get it reset.
I'm willing to retry again and keep going, but it's hard for me to get things without assistance, and I haven't been able to get any assistance.
Right. So here's what I'll do. I'll reset it one time.
Okay.
Mr. Young, do we have a specific reset date on our current schedule? Maybe about a month out?
We can do either August 12th or August 16th.
Do either of those dates work better for you?
Let's see.
August 12th or the 16th.
August 12th.
August 12th at 9 a.m. and at 1.
1. Thank you.
Okay, so we're going to reset it to August 12th, 1 o'clock. And that, I don't know what day of the week that is. Is that
A Monday.
That's a Monday, so it should be here in 2C, correct? So it'll be the same courtroom. You're getting notice now. The only thing I will tell you, without giving you legal advice at all, is that if you wanted to go over to the DA's office, ultimately, if I do find that an applicant has met their burden today, the case goes there.
Okay.
And you might talk to them about this DOB issue. Because unfortunately, if you come back August 12th without the date of birth, we'll be right where we are now.
I understand. Okay.
So, they're on the 3rd floor in the 136 Prior Street building, or you could always call them as well.
Okay.
But with that, you don't need her for anything else right now, do you?
No, Your Honor.
Okay, so Ms. Turner, you're excused. You have a nice day.
Thank you.
Thanks. Okay. Number 7, ending in 2372, Sarah Gacobo and William Harris aren't here at 1:30. That's DWAP. They both got good notice. Number 8, ending in 2391, Nigel Morgan, if you'd come forward, please. Ariel Mack is not present at 1:30. May I see number 8, please? Thank you. Good afternoon, sir.
All right, how you doing?
Good, thanks. We're not going to swear you in because you're the one who's the respondent. I just want to take a look at this. So Ariel Mack took out this warrant application against you, but they're not here.
Okay.
And got good notice. And it looks like maybe a family kind of allegation. They, like I said, got good notice to be here. I'm going to dismiss the application. Do you have any questions about it?
No, sir.
I don't get to the point of figuring out what actually happened. But if something did happen, if the truth is somewhere in the middle, please, if there's anything in hindsight that maybe you could do better or that you would think about doing differently, if there's any kind of counseling or anything that you want to think through differently, it does give you an opportunity to kind of pause and rethink things.
Right, I agree.
That maybe there's a better way to handle things. I'm not suggesting the allegations are true, but, maybe this is an opportunity to learn something from whatever happened.
Situation.
If you don't have any questions, though, you're free to go.
All right, thank you.
Yeah, thank you.
All right, have a good one.
Thanks, you too. Okay, so that's dismissed. Number 9, ending in 1228. If LaShonda Lovelace, could you come forward, please? Diego Ortiz is not here. Thank you.
Position 16 is it dismissed?
16, was that? Thanks. Before we get to number 9, I just want to announce on position 16, 2392 is Shida Yang. Are you back in the courtroom? You are. And Ms. Hastings, you're here. Is this correct that the application is being dismissed? Is there anything y'all need to talk about that I need to know? Okay, so Mr. Yang, you're free to go. You're both free to go. I'll accept that. It's DWOPed after mediation. And Ms. Hastings, I think that was your only case, correct? Is that your only case today?
Yes, sir.
Okay, thank you. Y'all both have a nice day. Okay, that was on number 16. Let's go back to position 9. Could you swear in Ms. Lovelace, please?
Yes. LaShonda Lovelace.
Okay, thank you. Good to see you again.
Nice seeing you too, Judge.
And I don't remember exactly, but I see my note from June 28th that you were here then, but the other side, Diego Ortiz, did not get notice. There was kind of an issue where you didn't really get notice either. How about for today? Did you get good notice?
Yes,
You did?
yes,
Okay. And you want to move forward with this,
yes.
with the application? So I do find that Diego Ortiz did get good notice and has had ample time to get here today. Everything in your application is true and correct?
Yes, sir.
Thank you. And so you say that he, Mr. Diego Ortiz, was introduced to you as a financial advisor and investor. Is that right?
Yes,
And he indicated to you that he could invest your children's college fund and increase the value of those funds.
Yes,
Is
sir.
that right?
yes, sir.
And then you, I guess, gave him access to $25,000,
Yes, sir.
more or less.
Yes,
And then he just took the money and disappeared.
correct. Stop answering calls, emails, and yes, send me to a voicemail and stuff like that.
How did he get access to the money?
We gave him a check.
You wrote him a check.
Yes.
Did you do that in Fulton County?
Yes,
Okay. Where was that? Did he have a business here or was it at your house?
yes.
Well, which one?
What, the check?
Right, when you wrote him a check
Uh-huh.
for $25,000, correct?
It was different about his 2 kids.
Okay.
Yes, so we wrote him a check and he gave us the mailing address to where the business address was, and we mailed the check.
And you mailed that you were in Fulton?
Yeah,
County,
I
you
live
mailed
in
it.
South Fulton, yes,
The city of South Fulton?
yes.
And when you mailed it, how much, I guess there were 2 checks or 1 check?
I think it was like 2.
How much were the checks worth?
One of them was like 5,000 and the other one was probably like 15. I have copies of everything.
Do you have that with you?
No, I don't have it with me today.
Okay, but there was at least 1 check
Yes,
for $5,000.
yes,
And was the purpose of the check for him to invest that money and have it grow?
correct.
So you'd have whatever you
Yeah, it was supposed to be
have that
something.
much more money.
Sort of like a universal account for kids.
Okay. And then
And it was a whole
the money disappeared and that was it.
bunch of crap. Yes, sir.
Okay, so I do find probable cause for one count of felony theft by taking. That's under OCGA 16-8-2. I'm not going to set or address bond because it's a felony charge. You'll sign the warrant while you're here today.
Yes, sir.
I'll sign it too. I don't know when he'll get arrested on the warrant.
Okay.
Whenever that happens, that initiates the case in the DA's office.
Yes,
And
sir.
then they'll be in contact with you about what they choose to do next.
Yes, sir.
Do you have any questions about it?
No, sir.
Okay, that's what I'll do. I don't know if it's maybe a couple checks, but I'm just going to go with the one count. Please have a seat.
Okay.
And then after you've signed the warrant today, you'll be free to go.
Okay. Now,
Look, you look like you have a question.
I do. So, with the other checks, do it go like multiple accounts or how does that work? Because I do have records and, I kind of rushed out and grabbed the wrong materials.
I understand. There is probable cause for at least one count of felony theft by taking.
Okay.
If you take somebody's property and the property is worth over $1,500 with intent to deprive them of the money. So not where, I take your money and then I'm going to invest it and then you'll get the money back, but I just take the money and run, then I'm finding probable cause for theft by taking. When the DA's office gets the case, they get to make the charging decision and they can decide whether they're going to add the other check or whatever they choose to do. They just have a duty to talk to you about it before they decide.
Yes, sir.
It becomes the state of Georgia versus Diego Ortiz.
Okay.
And that all gets started once he's arrested.
Okay.
Do you have any other questions?
Yes, sir. Now, how do I, what you call, I guess, put a lien on his bank account or something? Because I have that information as well.
Right. I can't give you advice on any of that.
Okay.
But ultimately, I'll just say this is a criminal case. Part of a criminal case could always be restitution to make a victim financially whole.
Okay.
And then, but when you start talking about liens and what precipitates a lien, I can't give you advice on that. There are a lot of good legal resources out there. You could go down to, is it on the 7th floor? The resource center
Okay.
on the 7th floor. So yeah, if after you're done, after you've signed the warrant and you're excused, if you want to go up to the 7th floor, you'll just go back out to these same elevators.
Yes, sir.
Up to 7, and then it's just right off the elevator. They might be able to point you in the right direction on something like that.
Okay. Great information. Thanks.
Any other questions?
No, sir.
Thank you, ma'am. Just have a seat. And I am glad to hear that your kids are planning for college. That's a big deal.
I know.
So you have a seat.
All right.
Thank you. Okay, so that was number 9. Number 10, ending in 2396, Elizabeth Ortiz and William Harris aren't here. That's dismissed for want of prosecution. It's 140 thereabouts. Number 11, ending in 2393, Ira Richardson. If Mark Williams and Ira Richardson could come forward. Okay. I'm sorry. Yeah. There you go. Let's swear in the witness, please. Thanks.
I do. Mark Williams.
And Mr. Williams, forgive me, I do want to get a quick update on a case. Do we have any update on the Brooks, Poland, and Weems?
Yeah, Weems is back there with the mediator and the other individuals from the Central Court was at that case from corporate. So I believe that they'll be making an agreement.
But you're not quite there yet.
No, and because part of the agreement is exonerating.
Okay, I can wait.
So, yeah, but if there's no agreement, then we'll have the hearing and we'll see what happens.
Got it. Thank you.
Yeah.
All right. Oh, good. So let's talk for a moment on number 11. So you're Mr. Richardson, correct? It's a little late. Excuse me.
but I ran out to the restroom real quick. And I told her I was coming back.
Okay. Well, it's a little late. It's not too late, but you got here just in the nick of time. Were you here for my announcement at all?
I sat through the whole thing.
Okay, that's good. And so let me take a quick look at the application. I thought I was going to hear the one side of the case, and we're not quite there. What I'm going to ask y'all to do, I see what the allegation is to talk to the mediator. And let me just talk about mediation for a moment. We offer it because it's a way in this criminal case for the parties to have some input, to have a voice in what happens. If the case moves forward beyond today, then it's the state of Georgia versus you. It's a prosecutor who's going to make the charging decisions. But on a case like this, it gives y'all an opportunity to try to work something out. When you're in the mediation process, I want to be clear, it's voluntary. You don't have to agree to anything. And if you can't agree or you don't agree, either way, it's okay. I'll hear the case today where the applicant has the burden of proof. And then we could just kind of see what happens. But the first thing I'd like to do is at least give you all a chance at mediation, because that's another way to resolve the case. And so
Understood.
if you could, just for the moment, we have one mediator in 2 or 3 cases. If y'all could just have a seat, and I'll let the mediator know that you're both here.
Thank you, Your Honor.
Okay, thank you. All right, so we're putting 11 down for possible mediation. Number 12, thank you, ending in 7033, Adetayo Tiamu and Demetria Tillman. Demetria Tillman is not here at 1:45. Thank you. So Demetria Tillman got good notice, no return mail or change of address. So we're going to move forward. If you could please swear in the witness.
Do you swear or affirm the testimony you're about to give in court today is the truth, the whole truth, and nothing but the truth, so?
Yes.
Okay, state your name for a little bit.
Adetayo Tiamu.
It's been sworn.
Thank you. And it's Tiamu?
Yes, sir.
Okay, thank you, sir. So I know we reset this case once before for notice, and it looks like last time neither party was here. Do you still want to move forward with your application?
Yes, sir.
Thank you. I'm looking at the application. You swore to everything that it was true and correct. So is that the case?
Yes.
Everything in here is true and correct?
Yes, and the damages are actually beyond what was initially discovered, because since the eviction, when we took back the property, we've seen the extent of the full damage.
Okay. And so it looks like this is a landlord-tenant relationship, correct?
Yes, sir.
You're the landlord and he's the tenant?
Well, she.
Yes, sorry, that she's the tenant.
Yes.
And is the residence at 1131 Martin Luther King Jr. Drive?
Yes.
That's where is it a house or an apartment?
Yeah, it's a house.
A house.
Yes.
Is that in Fulton County?
Yes, sir.
Thank you. Tell me, how did she destroy your property there?
So she fell behind on her payments, and we asked her and her boyfriend to leave because they fell behind, and they refused to. And then they got in a fight over a pistol in the living room on camera. I sent this footage to the police department, sent it to DFACS, because the kids were right there. And I did everything I could to have this situation resolved faster than this whole process normally takes. And no one did anything. And when they finally did get evicted, well, during that process before the eviction happened, she got arrested for something else. She came back to the home because it's multiple units in the home. She came back to the home. She called me on my phone and she was cursing me out, saying that I let one of the other tenants go in her unit, and then she said that give her back her stuff or she's gonna destroy my house. And then she proceeds to break TVs and put holes in drywall and all that stuff. And I had the audio too of her making the threats.
In terms of the damage to the property, is she on video doing it?
Well, she destroyed the cameras. Like, she ripped the cameras off the wall.
How do you know that she did the damage?
The other tenants mentioned it, and when I spoke to the police department, the police officer was there, and he was saying that that I can't have cameras in the common space, and if it was him, he would take them off the wall, and the next day all the cameras were disconnected. And for the officer to even say that, that was false. You know, I can have a camera in the driveway, the front and back porch of my home.
Did you ever have a conversation with her about the damage to your property?
I did.
And did she admit to doing it or explain or deny it or anything?
She denied it. And then I sent her back the audio of her, because the threats that she made are exactly what the damage was. So I sent her back the audio because I don't think she realized I was recording the conversation. And then she was trying to deny that was her on the audio.
And you're saying she still denied it even after that?
Yeah, I have text messages of the whole conversation.
And tell me again, specifically, she damaged, I guess, the video cameras and a TV.
Yeah, it was, so initially, the damages were the interior cameras, the exterior cameras, the television, and then I mean, it was a bunch of drywall that was damaged in their room, but I didn't put that on the initial report because I didn't see that. There was door frames on the units that was kicked in, I'm assuming from domestic violence. I have pictures of all of that. A lot of this stuff was seen once we took possession of the property.
Is there anything else? You know, you said at the beginning that there was more damage.
Yes, the sink in the kitchen was, I guess it was collapsed to the base of the, what is that, like the base of the cabinet. So they had 3 children. I don't know if the kids was in the sink. I'm not sure what was going on there. There was appliances that were damaged, like the stove is totally useless. The dishwasher had to be taken out, and all these things. I didn't even add that into the whole equation, because I know this is an arrest warrant. But I mean, am I able to hold her accountable financially for additional damages here?
Well, I can't give you advice on any of that.
Okay.
Let me ask you though, did she damage your property before or after she had been evicted? It was before that, I guess?
Yeah, it was before that. Yes.
Okay.
Yeah, I thought.
Let me just ask you a couple other questions. It sounds like it, but I just want to make sure the damage exceeded $500.
Oh, yes.
Okay. What I'm going to do is I do find that there's probable cause for 1 count of criminal damage to property, 2nd degree. That's under OCGA 16723. And I'm not going to set a bond. What'll happen is you'll sign the warrant today before you go. I don't know when she'll be picked up on the warrant, but when she does, the DA will get the case and they'll decide what to do with it. Do you have any questions about that?
Yeah, and I didn't mention there was also a $3,700 water bill. So what I was told was that they're just maliciously running water.
Right.
You know.
Here's what I would tell you is
And I had
that
to
I'm
pay that.
making. Sorry, didn't mean to cut you off. Go ahead.
No, I'm saying, and this is paid by me. You know, so
I understand.
Yeah.
Here's what I would say is that ultimately it's going to be up to the DA's office how to charge the case, if at all. So you might talk to them about it, let them know everything, and then they can choose whether to add charges. I'm going with the basic, like the prime charge that I hear from all of this, the criminal damage charge, and that will get the case to the DA's office, and then you can follow up with them. Ultimately, they choose what the charges are going to be, and then they have to prove it. And so, you know, I probably could on any given case, not yours necessarily, but in general, add 2 or 3 or 4 or 5 charges. But I'm going to go with the primary charge and leave that conversation to you and the DA. Similarly, if I added charges, they could remove them anyway. So that's why that's a better conversation for you to have with them.
Okay, are they going to reach out to me, or do I reach out? Like what is that process?
Well, the one thing that I can suggest, and I say this all the time to people, is that the marshal could escort you out after you sign the warrant to the DA's office, and you could just introduce yourself to them today while you're here. But ultimately, I would say from experience, just anecdotally, that they're not going to really know anything about the case until they get the paperwork. And they're not going to get the paperwork until she's arrested. And I don't know if she gets arrested next week or 3 months from now. It's hard to say when she gets picked up, but their case starts when she's arrested.
Okay.
And then they have a duty to keep you in the loop. They're supposed to reach out to you. I guess the squeaky wheel gets the grease. You could always call them, but they're not going to know anything about the case until she gets arrested. And perhaps the hard thing for you is going to be to know when she gets arrested.
Yeah, I have another question. So,
Good, but the DA's office, I think that's a question that they are prepared to answer. So you might ask them that. Yes, sir.
so if as far as her getting arrested, if she's not at the property that you guys mail the notices to, then what happens? Is it like when she gets pulled over on a routine?
It could be
routine traffic
anything.
stop?
She could be at the airport going through security. It could be the marshal or the sheriff has her on a list, where they're going out and serving warrants. It could be running a stop sign, like you were saying.
Okay.
Any number of ways. I don't know how actively that warrant process will work, but it's going to be one of those things.
Okay.
So please have a seat and we'll bring you the warrant in just a few minutes.
Okay. Thank you.
Thank you. Number 14, ending in 2371, Zyque Willis and William Harris. Mr. Harris, if you could come forward, please. All right, we're not going to swear him in. Good afternoon.
Good afternoon.
14. I like your t-shirt as long as it's not directed at me.
Thank you.
All right, thank you. Even though it might be true. We've got 2371. And so this is a warrant application regarding a car against you. And Mr. Harris is not here. And for whatever reason, he's with Avis. They don't want to move forward with this case. It might be that they recover the car, but it's I guess a Chevy Malibu with a Florida tag back in May saying that you legitimately rented the car and didn't return it when you were supposed to. I'm going to dismiss the warrant application against you because he's not here. Do you have any questions about it?
No, sir.
Okay. So, I don't know if something else happens on the case later or what the underlying issue was, but I'm dismissing the warrant application against you. You're free to go.
All right, thank you.
Thank you, sir. You have a nice day. Number 15, ending in 388, Frederick Wright and Ken Mullins. Neither party is here at 2 o'clock. And so I'm going to DWOP number 15. Okay, so we're waiting on 4, Brooks and Poland. We're waiting on number 11, Richardson and Williams. And Weems and Pullman. Number 13. And I think, Mr. Young, that's everybody. Number 15. That was DWOPed.
Okay, so dear, some documentation. Okay, so, and is it the time for you just? What should you think? Oh, okay, thank you. I'll actually get the best and everything's done. Okay, thanks. No problem.
Thank you.
Okay. No.
Yes. Okay. I think it depends on what the ultimate result is. Yeah, I mean, I'm fine with them blended if, you know, if the parties want to work something out. Okay. Yeah, either way, thank you.
Yeah, so I'm familiar with the numbers, but you can do 200 a month. That's right over, I think this is, isn't it 14, is it 14.4? It's 2. Yeah. That's basically what it would be. You can enforce that or use it, however, it's not in the title. So it's a 5 for PVD.
Here you go. Yes, sir. Can I ask you a question? I don't know why it just kind of pops in my head, but with the stuff with the Trump Saturday, is that something that y'all talk about at all when there's like some event like that, just to?
So we had it because we did.
Mm. Okay. Yeah, just curious. You know, I think, well, first off, like nothing political, you know, it's, I look at it primarily as like a security concern. Like, how does something like that even happen? And so you have to suck out the, like your own personal feelings about something. Now, my own personal feelings are that I don't wish harm on anybody. I want every place to be safe. And, you know, thank goodness it wasn't worse than it was. But that's, you know, like sitting here, and that was my first thought was like, why isn't it? And even after it happened, it's slow moving.
Like,
Like,
it should have been,
yeah, like they,
like everybody confused and then, okay, let's respond.
yeah, like they should have, you know, he's an old man. They should have
Right,
just
yeah.
tackled him and gotten him the hell out of there. End of story. And like, I know that, like the images, to me, like if they're, like in terms of, like if there'd been another shooter or something else, like he was just a sitting duck. You know, so I didn't understand that part of it.
To me, it was crazy. Like you said, that was my thing too. Like, how do y'all even let something like this happen?
Yeah. What I, yeah, it seems like usually in situations where there's anything like that, if there's a problem, like there probably were a bunch of mistakes.
Oh,
But
yeah, a lot of people had to drop the ball.
Right.
For that even to get to that.
You know, I don't see it as like one thing, like I would really want to understand. And, you know, it becomes this whole political thing, but to me, it's more of a safety thing. And, you know, you don't really think about it, but like I'm involved with some different, like judges or organizations. It's like the first thing for us is, it's always like we have to have security, like security.
Right.
And so, like, I don't really think about it so much when, like, I mean, if you saw me just walking around the community, like you wouldn't even know who it was, but, you know, that was my thought.
So, do you have like a regular?
I'm sorry.
Do you have a regular, like, do you go out and Yeah.
Yeah.
Even
Yeah.
if it be scared, like, what if somebody with natural?
Yeah, I mean, I think it's something you're careful about.
Right.
You know, I used to think, like I was a DA for a long time, and I'd prosecute some, like some murder case, and I'm just walking in my car in the dark
Right, yeah.
by myself, and I'm the one, like going after somebody.
Right.
And so I thought being a judge, because you're neutral, like, nobody would be really against you. And also magistrate court, like it sometimes isn't the most serious stuff, but it's the kind of stuff that people get really upset about.
Yeah.
Like you're kicking people out of their homes and you're taking their last dime, and it was very personal. So
It's nowadays.
I think you just have to be, very much aware.
Yeah, at all times, especially now. Like, it's almost comfortable.
Yeah.
Have
I was
you
just
seen
curious.
Have you seen on the Squires calendar or heard about it?
No, we were talking about it. I was talking to the judge who's done it. We just started.
Right.
I've had a case here that I thought should have been one of those cases, but no, we've just started them. They seem to be going okay. Like,
That's what I was about to.
where a lot of times they can kind of work it out. Like it's,
Right. Yeah.
like they're a good number. Like you think about squatters being one thing, but I think a lot of squatters are people who legitimately thought
Yeah.
like they were victimized, like somebody sold them the place and they're or rented them the place and they're paying money.
I did an eviction like that last Thursday. We went to a lady house and when we got there, she was confused.
Yeah.
And I'm just like, hey, you pay your rent? She was like, I've been paying my rent every month. But she was paying it with somebody.
Right.
Yeah. And I felt so bad for her. But,
Yeah, to me, that was the hardest when I do dispose, especially when I first started. There's that JOP calendar.
yeah.
And that I thought, oh my God, I've like gone after child molesters and murderers and like some really bad people. And like then you get those cases and you just feel really bad because the law is very clear and the law is the way it should be.
Right.
But then, you're just telling people like,
Right.
please move in the next 7 days because otherwise the marshal is going to be out there.
That's insane. That's why, like, sometimes with us, if I be out somewhere in my uniform, or like somebody asks, like, oh, you're a marshal. Oh, yeah, how do people do it? And I'm like, no, like, don't say it like that. They sound bad.
Are you getting some of the like that's right where you like pick up the boxes and stuff? Like there's kind of a new thing where people are like you can just get a job to be one of the people.
Oh yeah, so like when we do evictions, it's their crews.
Yeah.
With us.
Right.
But they.
Yeah, you're there just to make sure everything goes. Yeah, that seems so strange to me. Anyway. All right. You're almost there. Mr. Young, we're not waiting on, I know we've got the mediator stuff, but are we waiting on anything else? Okay. I appreciate everybody's patience. Just bear with us. Oh, thanks. I'll be back in a minute.
This is crazy. Yeah, it's a home. Yeah.
I know about it.
Yeah, I know.
No update? Let's watch the time. Say like another 10 or 15 minutes, we should check. Could I see those 3 files? Thanks. If I could ask, do we have any updates?
We have an agreement, Judge.
You do?
Signed the whole E-Doc.
Okay. Is that on both cases?
Yes, but
Okay, thanks. Are they still with the mediator or is she talking to somebody else now?
she just sent us like the E-Doc to sign. So
Okay.
I guess right when it's
Okay.
signed, she'll
Thank you.
go on to the next test.
Um,
All right, can I talk to everybody on the two cases? Is everybody out now?
Yes.
Okay, thank you. So let's go on the record, position 4, 24 MAGC 02389 and 13 ending in 2390. So we've got 3 of y'all here. Is the announcement that both warrant applications are being dismissed?
Yes, it is.
Does anybody have a question about any or either of the 2 cases?
No, sir.
And it's not contingent on something in the future?
Just payment.
Just
monthly payments.
monthly payment. And did y'all work out a written agreement for that?
Yes.
But you're not asking for us to put it down for any kind of compliance. Today is the end of it. Does anybody have questions on either of these 2 cases? Okay. Well, I'm glad that y'all were able to talk about it. And if you're satisfied, then the court's satisfied. Everybody's excused. I am going to ask the marshal maybe to direct who goes first. I'd rather y'all leave separately, but everybody's excused, subject to that. And have a good afternoon. I hope your son still wants to be a lawyer after today.
Probably not.
Probably not.
No, I'm just kidding. I'm probably steering him on this path.
That's right.
But yeah, good to see you as always. Take care.
You too. Thanks. Bye-bye. Okay, so that then leaves position 11. And so have y'all talked on position 11? I'll ask the mediator. Were you aware of that one?
I was not.
So we have number 11, and it might have been because one party or the other was a little late, but it is Ira Richardson and Mark Williams.
I'm still here. Would you like to talk with them, Judge?
Yeah, if you don't mind, it looks like one where at least I want to give both parties that option.
All right, sounds good.
Okay, thank you. So let's hold on number 11. Oh, this is not working. And thank you to pretrial services. I know we're not asking you much right now. We have one case left.
No problem, Your Honor.
Thank you. We just don't want to forget you.
You did.
Mr. Young, did you ever figure out who that lawyer was?
What was it?
Did you ever figure out who that lawyer was? I cannot remember his name. I should have had the sun come up. So introduce yourself to me, young man. So one thing I really miss about Zoom, besides the fact that you can do it in your pajamas, but is you'd always have the person's name, I think the hardest thing was when we were doing it both ways and you'd come in every once in a while. It was hard to get used to it. Well, he didn't file an entry, so I'm just going to say they're pro se. Yeah. Am I done with the orders? We could, well, there's the one that I'm waiting on.
You just waiting on one.
Yeah.
I can scan the other.
Are you sure?
And I'll give it back to you so you can give it to me, check.
Okay. I've got this morning's too, but I guess I'll do those separate. Or can you do those also?
No.
Right.
You probably already just both right now.
Yeah, that's not a problem. So yeah, here's everything except for 11. Thanks. Might as well make good use of our time.
Yeah, I just finished your vote.
You know what? I'll walk these down to Mr. Tay. So you'll email them? Or are you printing them out?
I'm just scanning one to the pics and then I was gonna go back to you.
Oh, perfect. I'll wait.
So then once I get them, I'm just gonna put back in the book.
Got it. I hear you. There we go. Yeah, Mr. Young, this morning was kind of interesting, trying to organize things. I don't know if you heard, but we had 16 cases. They were all the same. Be careful. Excuse me. Who is J.D. Vance? Just saw where that's who Trump is pointing as his running mate. Ohio Senator. All right, there you have it.
Is it even? Wait. We all, I mean, not all, I mean, not all of them. Judge, we're at an impasse on this case.
At an impasse?
Yes, sir.
Okay, not a problem at all. And so I think, Mr. Young, that's our last case, so our mediator can be excused. So you're welcome to stay.
Thank you, Judge.
And you're free to go. Thank you. All right, so let's go on the record. This is position 11, 24 MAGC 02393, Mark Williams and Ira Richardson. If y'all could both come forward and be sworn.
Both parties raise your hand. Do you swear or affirm the testimony you're about to give to the court today is the truth, the whole truth, and nothing but the truth to help you?
Yes.
All right, state your name for the record.
Mark Williams.
State your
Ira
name.
Richardson.
All right, you can have a seat. You can call it.
Thank you. And Mr. Williams, you're the applicant, correct? If you could come up to the podium. I do want to just speak to both of y'all briefly. So, we offer mediation, and I understand that this case is at an impasse. Is that right?
Yes, sir.
Okay. So whatever was said or done during mediation won't impact anything now. I'm just going to base my decision on what I hear and apply the applicable law. And I want to just remind you as the applicant, you've got the burden of proof. The standard is probable cause. Did a crime probably happen or not? And so I'm looking at elements for a particular crime or crimes. If you meet your burden, and I don't know if you will or not, then a prosecutor will make the ultimate charging decision and have the ultimate burden of proof in the case if they decide to go forward with the case. Similarly, if you don't meet your burden, they could still go forward with it. For the applicant, I just want to remind you that you don't have to prove anything. The burden never shifts to you. And even though you were just sworn in as a witness, think now a little bit, because I'm going to come back to you in a bit and to ask you if you want to testify.
Yes.
If you choose to testify, that's fine. You can have your day in court. You'll be treated like any other witness.
Okay.
But you also have the right to remain silent, and your silence cannot be held against you whatsoever. Did you have a question about that?
My question, would I also have the opportunity to question him as well?
Correct. Now, the applicant is already a witness. And so you could ask questions on cross-examination of him, and that still protects you because your questioning is not evidence. Only his answers to your questions is something I can consider. So just kind of keep that in mind too. Whatever question you ask, if you say on January 1st, what time was the sunrise? Your question is not anything I'm considering, only the witness's answer to the question. On the other hand, if you choose to testify, you'll be treated like any other witness.
Right.
So that's a decision that you'll have to come to a little bit later. We'll revisit it, because if you choose not to testify and exercise your constitutional right, I would not hold that against you. And you don't have to prove your innocence. But yeah, to answer your question, you can ask questions.
Okay.
Similarly, I can ask questions of a witness as well. And so, but what I'm going to do first is, as the judge, ask a couple preliminary questions. Then, Mr. Williams, you can testify. And then, Mr. Richardson, if you have any questions for Mr. Williams, you can ask without it impacting your right to remain silent. Okay, so Mr. Williams, I'm looking at your warrant application. You swore that everything is true and correct. And so is that the case? Everything in your application is true and correct?
Yes, Your Honor.
Thank you. And so you applied for this warrant, it looks like May 7th, 2024. Is that correct?
That is correct.
And you say that the actual crime occurred May 2nd, 2024, correct?
Correct.
The address listed is 1700 Northside Drive. Is that correct?
Yes, Your Honor.
And that's a business.
Yes, Your Honor.
Thank you. And I think that you're here representing Brockwell Logistics.
That is correct.
And what's your relation to the company?
Managing manager.
You're the manager? Okay. And you allege that, I guess, Mr. Richardson worked there, had a company vehicle, was terminated and refused to return the vehicle.
That is correct.
Thank you. And so, sorry, let me. get to a page where I can write. What's the year, make, and model of the vehicle?
The year is 2017. The make is a Volvo, and the model is a 670.
670?
Correct.
Is that a car or a truck?
It is a truck.
A truck. Do you know the approximate value?
34,000.
34,000. So briefly tell me, I guess, when was Mr. Richardson terminated and what happened with the truck?
The termination date would be May 1st.
Okay.
He was asked to return the vehicle. He stated that, and I quote, "Like I said, when you pay me in full, you can pick up your truck. I cannot be picked up until then, full payment, and you can pick it up. Keep in mind of this private property."
Okay. Have you, to this date, recovered the truck?
I have not. This was a leased vehicle, and I have not recovered it as
Okay.
of this time.
Anything else you want to tell me about the allegations?
There were several attempts by me to have him return this vehicle and the property that was in it. Those negotiations did not pan out. And because of that, I went ahead and filed for the warrant application, along with a stolen vehicle report as well.
How long had Mr. Richardson worked for the company?
About 3 months.
3 months. Okay. So, Mr. Richardson, do you have any questions for
Yes.
Mr. Williams? Now, I do want to kind of set up a rule that it's just a regular court rule, applies to every case. If you could, it's kind of awkward and weird. I'm not quite sure why we do it this way. It's just the way it is. Even though you're asking Mr. Williams a question, just talk with me. So if you could just ask the question, but
Okay.
kind of address me as you ask him the question.
Okay. Mr. Williams, you said that I stole the truck. Where was I coming from with the truck before it got to South Carolina?
I do not recall at this time. I do not have that information, any of the driver's schedule or any of that information in front of me at this time.
Isn't it not true that you told your new driver manager / broker that he was stuck in Dallas, Texas for 3 days? We need to get him out of here. Do you recall that?
Repeat the question, please.
Do you recall telling your new driver manager / broker he was stuck in Dallas, Texas for 3 days? We need to get him out of here.
To my understanding, Your Honor, Brockwell Logistics did not hire a broker driver manager.
Okay. Now, keep in mind, Mr. Richardson, I'm just going to let this unfold, but what I sometimes see is that when a party questions a witness, they really want to testify. And here especially, it's really important to understand the difference because you have an absolute right not to testify. And so let me jump ahead just for a moment.
Okay.
Because it might work better this way. Let's just address that issue first. So do you understand you don't have to prove anything in this case?
I understand.
And the burden never shifts to you.
I understand.
Let me go ahead and ask you though, because some of what you're saying is starting to sound a little bit like testimony and less like questions. Have you thought about whether you want to testify or exercise your right to remain silent?
Well, I want to testify because I have all the paperwork
Okay, so.
to everything that was done.
Right.
Everything.
I think if you could have a seat, Mr. Williams, and Mr. Richardson, if you could come up to the podium. Thank you. So, and y'all swore in both witnesses, correct? Okay, so I just want to make sure I'm clear on this, Mr. Richardson.
Yes.
So you understand your right to remain silent.
Yes.
You choose
I
to
choose
testify.
Yes.
And you understand fully you're going to be treated like any other witness, for
Yes.
better or worse.
Yes.
And I can ask you questions, the other side can ask you
Yes.
questions. And by doing that, you are waiving your right to remain
Yes.
silent. And that's what you want to do.
That's what I want to do.
Okay. So you're now a witness, and you also understand we're recording everything.
Right.
And that ultimately the DA or the solicitor could use anything that anybody says in court here
Against
today
them. Right.
to build their case. Okay.
Right.
So I do find that you freely and voluntarily waive your right to remain silent, and you are a witness.
Mhm.
I think it might make better sense at the moment just for you to testify. And then if you still have questions for Mr. Williams that are truly questions,
All right.
I'll give you that chance as well.
Okay.
Similarly, I'll let Mr. Williams ask you any questions if he has questions.
Okay.
But right now, you're the witness. So tell me your side of the story. What happened? What do you want me to know?
I came in on March 8th to drive for Mark Williams, Brockwell Logistics. Mark Williams is the owner to Brockwell Logistics. Within 2 months of being out there for Mark, I started getting sick. I told Mark, I said, Mark, I have a rare form of eczema. I can't miss doctor's appointments.
Okay.
If that happens, I'm going to end up back in a hospital with a number 7 needle in the arteries in my neck. I made it very clear to him. When I missed the 2 doctor appointments to get the medication, I was still up here. And I said to Mark, I said, Mark, I need to get to the doctor. Mark booked a load going to Dallas, Texas. Let me back up.
Can I ask you, before you back up?
Yes.
I'll back up a little bit. So you agree that you work for the company, correct?
Yes.
And you drove a vehicle for them.
Right.
As part of the job.
Right.
And that was a 2017 Volvo.
Bubbles. That's correct.
Okay. And you don't dispute that it's at least worth more than $1,500.
I have no quorum with that.
Okay. And at some point, were you let go, or I'll just say you stopped working there?
No.
You still work there now?
No, I don't work there now.
Right.
I finally gave up on Mark, but I have to back up a little bit.
Because ultimately what I'm going to ask both sides is, I guess essentially, did you keep the truck longer than you were supposed to?
No.
And you say no.
No, and I'm going to explain why.
Okay.
There's
Go
an
ahead.
explanation for it. Before I went to Texas, Mark got a phone call from the insurance company telling him that they took me off the insurance because my medical card expired. That's FMCA, Federal Motor Carrier Administration.
Okay.
Then we have another side that's called DOT. If your medical card expires, they give you 1 month to get home, get it fixed. Even if they put me in a wait station, they wouldn't arrest me. Get it fixed. Then your license become inactive. They will put your license back active.
Are you talking about medical insurance or
No.
auto insurance?
For the truck.
Right.
Now, so what Mark did was use my cousin's license and medical card as him being the driver to keep them from canceling the insurance. But you never sent me home. If you had sent me home, they could have reversed it the next day.
Okay.
What Mark did was sent me down to Dallas, Texas. My arm was already leaking pus and fluid. When he got me down there, he couldn't get me back. He's not a dispatcher. You're just learning. I've been doing this 41 years. You're not going to tell me. So he hired Avery Darby to book the loads. Mark shouldn't say that he didn't do that, because all you simply have to do is get the rate card from the broker, and you will see who the driver manager was and who the driver was. I want every single load that was booked on that truck. So that means what? You lied. Now, when he told Avery to bring me back, but bring me to Georgia, so she's new. She don't know I don't live in Georgia. But that morning, I was very sick, close to going in the hospital. I don't want to go to the hospital in Dallas, Texas. I want to go home. You failed me on that, Mark. So now you told Avery to bring me to Georgia for what?
Where do you live?
South Carolina.
Okay.
Now, so when I sent Avery a text and an email and the pictures, she said, oh my God, I was swole up. So we started talking. She said, I thought you lived in Georgia. I said, no. I have a home in North Carolina. I have 2 houses in South Carolina. I own property in South Carolina, and I own a condo in Elizabeth, New Jersey. He told her not to send me home. Don't worry about it. She said, because she asked him, she's new. She don't know. She said, well, when do the driver like to go home? Don't worry about him. Just run him. He live on the truck.
Okay.
Now, so when I got home, I took when I dropped the load in Georgia, she got me another load from Georgia that same day, sending me to Orangeburg, South Carolina, which would have put me 45 miles from my house. So if I stole the truck on the day that you said that I did, how did the truck get out of Georgia into South Carolina on a delivery with the driver known to the broker, as Ira Richards said? How
So
did
what
that happen?
happened? What happened to the truck?
No.
ultimately?
So what I did was she sent me home so I can get medical attention. That's why she sent me from Georgia to South Carolina. The closest she was able to get me was to Orangeburg.
Okay.
Now, so from Orangeburg, I drove home. I pulled the truck up on my property, went in the house and dropped. I can't see it now. I delivered Thursday. I was too sick to make it 45 miles from my house to go home. I didn't leave until Friday morning. This was on a Thursday.
Okay.
I have the paperwork in my briefcase. I left Friday morning, went home, but I can't see the doctors to get the medication until Monday. See, I had to do a medical card at the same time.
Okay.
Now, when I went to Low Country to do the medical card, my blood pressure wouldn't come down because my arms and neck was inflamed. So what they did was, he said, okay, we're gonna wait. Now he's the RN, I don't know, he's just, I'm gonna show you some things to do so we can get that blood pressure down.
Right.
The blood pressure came down, I passed it. I told Mark I passed it, but he told me, don't leave because I gotta check you again. When he checked me again, my blood pressure was back up again. He said, you know what? I'm not gonna let you drive. I'm sending you to your primary doctor. When I got to the primary now, I called DMV and the lady said, well, you could email me your medical card information. That was on the 5th. My medical card didn't clear for my license to become active again until the 6th. So all this time, Mark is talking to me. Hey, Ira, I'm sorry, I was gonna call you. I want to apologize because I could have handled that better. Trying to run the game. Then you offered to put me on your company's account.
Can I ask you a question?
Yes.
So he mentioned this text message basically saying you owe me X amount of money.
No.
You dispute that?
No.
When you say no.
Mark owed me money.
Right.
So Mark was afraid that I was going to quit on him. Is why he called the police and told the police in Manning, South Carolina, there's a warrant for Ira Richardson's arrest. He stole the truck. Now, made a mistake, Mark, because every police officer and the judge know me and my entire family. So the police didn't even waste no time. They got in their car, they came straight to my father's house. I was sitting in the truck. I told the police officer that I was not going to give him back the truck until he paid me. Let's understand something. My mother's 81 years old. I have to take care of my mother. I don't have time for you to play with my money. Mark, know what this is about. I'm testifying now. I'm going to give it to you real. Now, since we swore to tell the truth, let's tell the truth. You didn't want to pay me, Mark. My mother, I called, my mother, they notified me when I was on another load for him in Florida. My mother had COVID and pneumonia in both lungs. I'm in Florida. All I have to do is come straight up to 95 and get to my mother.
Can I interrupt you though? Because I think
Let's go.
we're getting off field, off a little bit from what I need to decide.
Mm-hmm.
So let's just pause for a moment.
Mm-hmm.
What I have to do on a case is listen to the facts and try to figure out, okay, I want to believe Mr. Richardson, I want to believe Mr. Williams, and I will believe both of you to the extent that I can and figure out, okay, where do you disagree?
I disagree.
So far, I don't really hear a big disagreement. It kind of sounds like you're both saying the same thing.
No, we're not.
Where is he wrong?
Because
Where
when
is
Mark,
it different?
once Mark called the police and told the police that there's a warrant for my arrest in Georgia.
Okay.
And they came, and they were looking to come to arrest me, and I was going to go with them.
So what happened?
But he couldn't because they couldn't find it in the database. They kept trying to pull it. They kept trying to pull it. Said, well, we can't pull it. We can't find it.
So at that point, you've still got the
Now,
truck.
I still have the truck. So I said to the police officer, because now I'm finished with you, Mark. All I want to do is take all my belongings off this truck and put it in a storage room and turn the truck over, the trailer, and the keys to y'all. Why? Because why would I drive the truck from South Carolina and come back to North Carolina when you're setting me up to be arrested?
Can you get to the, I'm very interested, and then why didn't that happen? So I assume from everything now, they don't have the truck. So what happened to the truck?
So now I'm in contact with Freedom Way, who is the owner of the truck, right?
Right.
Because Mark wouldn't come and get the truck. He couldn't come and get the truck because you don't have a CDL license. You can't come and get the truck again because you don't have a driver. You tried to use Devin Washington, who was my first cousin, to come and get the truck. And he didn't want no part of it. So now you're stuck.
Okay.
Now, I'm not going to move it. Once you called and said I stole a truck from you, I don't mess with you anymore. I'm done.
And so
Now,
did
so
you just-
Freedom Way.
But I'm sorry, I've asked the question a few times.
Mm-hmm.
So my question for you, please answer the specific
Okay.
question.
Okay.
Is, did you ever return the truck to Mark?
No. I wasn't going to drive the truck no more. Once Mark said I have a warrant for my arrest and I stole the truck.
So
But
my
what I
next
did
question
do was
is,
contact Freedom Way.
let me finish.
Mm-hmm.
Sorry, I don't mean to talk over either one of you, but again, what happened to the truck?
I contact Freedom Way, who is the owner of the truck that leased the truck to Mark.
Did they pick up the truck?
They picked up the truck. I have the message from Freedom Way in my phone as we speak. I just couldn't print it out.
Did they give you some paperwork? Did you sign off on something so that?
No, they had to sign it off with the police. They had to sign it off with the Manor Police Department because I gave Manor Police Department the truck, the trailer, and the keys.
Do you want me to see these text messages? If so, you need to show it to Mr. Williams first, and then, Mr. Williams, I'm going to ask.
Freedom Way said to me.
Don't say it yet, but just, can you pull that up?
Mm-hmm. I told Freedom Way that I was going to court. Nathan said, "Are you serious?" I said, "Yeah." He said, "You got to be kidding me." I said, "No." He passed me over to Tony. You are aware of who Tony is, right? Mr. Williams?
So hold on.
Sir, it doesn't.
Oh, okay.
Thanks. Ms. Young, can you print out number 11 again? Because I marked it up. Thanks. Thanks.
Pass this to the judge. You think?
Okay, so I'm gonna let him see it first and I'm gonna get it.
Mm-hmm.
So I'm going to mark this as applicants 1. Mr. Williams, are you okay with me looking at it?
Yes, sir.
Okay, so I'll admit it. And so let me ask you, Mr. Richardson. So what am I looking at?
If you're looking at the one that have Freedom Way on it,
What I'm looking at says to whom it may concern.
okay,
I,
that's
Mark
from
J.
the first dispatcher.
So
Mark J. Randall.
what's the gist of this?
Basically letting you know the things of how Mark really is. I didn't know when I first came in. I learned it as I was going along. Come to find out there was 4 other drivers that was done the same way I was done before I got there. In fact, the driver before I got in the truck was under the belief that the truck was coming in for service and he would be going back out with the truck. But what Mr. Williams did was put me in the truck and never answered that driver again.
But let me ask you, it's a very narrow issue that I need to figure out.
Mm-hmm.
And I know there's a lot, let's just assume for argument's sake.
Right.
That, and this is hypothetical, Mr. Williams. I mean, this could be anybody. Let's just say that Mr. Williams was the worst employer ever
Mm-hmm.
in the history of the business.
Mm-hmm.
But at some point, you stop working there and
The day that
you
right.
still had the truck. Even if you gave the truck to somebody later,
Mm-mm.
did you keep the truck after you had stopped working there?
No. No, the truck, the day that the man in police department came to me, because they wanted to arrest me, but they couldn't pull the warrant out of the database.
Okay,
So at that point, I asked them to let me get my belongings off the truck and turned the truck over to them,
right.
the man in police department.
And do you have, I saw the one letter, it froze, it went back to the home screen with a lion on it. So I did read it a little bit. What was the gist of that letter?
The one from Freedom Way?
From Marche.
Marche is basically saying that Mark is a crook.
What about, do you have any documentation showing that you turned the truck over to the owner of the truck?
I spoke with them, and they let me know that they have to, in order for them to get it, you have to be an official from Freedom Way
Right.
The owner of the truck to get the truck.
What was the date that you stopped working for this company?
On the 6th.
The 6th of May?
May.
Okay. And Mr. Williams, according to your records, when did Mr. Richardson stop working? You said May 8th, correct?
May 6th.
May 6th, I'm sorry. What do your records show?
1st of May.
May 1st. Okay, so the applicant says May 1st, the respondent says May 6th. And now it's July 15th and you still haven't received the truck back.
Negative.
What about this idea that, it kind of makes sense that Mr. Richardson did turn the truck over to the owner? You were leasing the truck, correct?
I was leasing the truck, Your Honor.
But have you heard, did the owner contact your company to say, all's good, we
Negative.
recovered the truck?
We have not received any official communication from that company.
Have you, and so you haven't gotten any communication from them one way or the
State
other?
in recovery, no.
Okay.
Your Honor.
You get a communication from them saying that they had not recovered it?
I have not.
Okay. Yes, Mr. Richardson.
Your Honor, Mark said that I was terminated from the company on the 1st. How can I be terminated from the company on the 1st when I made a delivery from your company, me listed to the broker as the driver in Orangeburg? How did that happen?
Let me ask you this, Mr. Richardson. So let's just go with the May 6th date that you give, that you stopped working for them May 6th.
Right.
When did you turn the truck over to the owner?
No, the owner came.
I'm sorry, when did the owner take?
I don't know exactly what day they came to get it from Manning Police Department. Once I turned it over to an official, the police officer, the police station, if you had that key to that truck, y'all are the ones that's watching the truck and the trailer every day until they come and get it. I'm finished. There was no way I was going to move that truck anymore once you told them I stole the truck. There's no way I'm going to move it.
I understand, but if I hear you correctly, the owner took possession of the truck, correct?
Yes.
But you don't know what date that was?
No, I can call them and ask him, because they're still there right now, and have him to send me an email immediately and hand it right to you.
Right, but my question for you right now is, can you say the last date or a date after, let's say after May 6th, that you were in possession of the truck?
I was never in possession of this truck or the trailer anymore once I gave it to the police department.
But you can't say when that was?
I gave the keys to them on the 6th.
Okay. So it would be your position that if you were let go May 1st, you shouldn't have had the truck as long as you did. But if you stopped working for them May 6th, then in your opinion,
I would have had possession of the truck.
Through that.
See, I had to go do a physical. So I'm not thinking he's going to do what he's doing. I went and got the physical May 5th.
Is there anything related to your possession of the truck that you haven't said? Anything additional?
No.
Okay, please do me a favor. Have a seat just for a moment.
Okay.
And Mr. Williams, do you have any questions for Mr. Richardson?
Yes, I do, Your Honor.
Okay, you can sit. Both of y'all can sit where you are. Same thing though, if you could, you're asking him the question, but refer to me.
Yes, sir. Mr. Richardson, could you confirm that you stated on May 2nd that you refused to return the truck until you receive full payment? Did you or did you not communicate? Excuse me?
I did say that.
Okay. And so would you also agree that on May 2nd, I requested that you return and surrender that vehicle? And you
asked me to drive the vehicle to Georgia.
So you refused to surrender the vehicle on May 2nd?
And I didn't refuse to. You wanted me to drive the vehicle to Georgia when my license
Your
was
Honor?
inactive. I cannot drive the vehicle, I can drive my personal vehicle.
Please pause just for a moment. Do you,
Your Honor, I would like to submit text messages showing that that is not an accurate statement from the witness.
okay, well, the first thing is I do want, excuse me, Mr. Richardson be allowed to answer the question.
Okay.
And not going into other stuff, but I don't think you were finished with your answer.
A yes or no
Was
what I
there,
was looking for.
well, there's yes and no, and then you can explain your answer.
Okay.
Were you done answering the question?
No.
Okay,
The reason he did ask me to bring the vehicle on the 2nd. I can't bring it on the 2nd. My license is on the commercial vehicle side is inactive. It never became active until I got the medical card, emailed it to commercial vehicle, and they cleared it the very next morning, which was the 6th.
okay, that answers the question.
I can't drive it.
Now, next is that Mr. Williams, you want me to see a text chain, I guess?
Yes.
Okay, same thing, we need to show that to Mr. Richardson.
Your Honor, I don't need to see because I said every word what he said. I don't need to see it.
Okay,
What I'm
if you don't want to look at it, I want to give you the opportunity to look
What I'm
at it.
saying to him is that you're trying to force me to illegally drive a commercial vehicle.
Please
My
pause.
license is-
Please pause. I mean, we're informal, but we have to be a little formal about this. Are you okay with me looking at this? Okay, so this is admitted. And so this is, let me just ask Mr. Williams. So I see Wednesday and Thursday and Friday. What are those dates?
The date, that, I'll tell you in 1 second, Your Honor. That Wednesday and Thursday, Wednesday is May 1st.
Okay,
1712.
okay.
The Thursday is May 2nd.
Okay, so on May 1st, am I correct, Mr. Williams, you text to Mr. Richardson on May 1st, are you going to be able to drop the trailer tomorrow? Is that correct?
Correct.
And then on May 2nd, you contact Mr. Richardson again, seemingly, I guess you had not heard back from him on May 1st.
Correct.
May 1st at 17:12, so 5:12 p.m. So then on Thursday at 13:48, so it'd be 1:48 p.m., is it correct that, Mr. Williams, you text Mr. Richardson again, this time you say, "Dear Ira, per our conversation, you have acknowledged that you will be turning over the truck, its keys to the driver that's en route. We have also established that should this truck not be surrendered today and recovered today, that this would be reported to the authorities." That was your text to him on the 2nd.
That is correct.
Correct. And then also on the 2nd, you're saying that Mr. Richardson texted you back and said, "Like I said to you, when you pay me in full, you can pick up your truck. It cannot be picked up until then, full payment, and you can pick it up. Keep in mind, this is private property." That was on Tuesday, May 2nd, correct?
Correct.
And then on Friday the 3rd, he sent a note, texted you saying, "What's up, Mark?" Then you responded, "Can I call you later?" And he responded, "We need to talk ASAP." That was on May 3rd, correct?
Correct.
Okay.
Now, can I ask a question to part of what you just read?
Well, we're not going back and forth like this, but here's what we will do. I'm considering this, and it does fit into the time frame. And so I'll just let both of you know that it appears to me that as early as May 2nd, that Mr. Richardson, you acknowledged that you needed to turn the truck back over, but that it wasn't about the medical or the car insurance or any kind of insurance. it cannot be picked up until you were paid, until you got full payment. Then he could pick it up, correct? And so you don't dispute
I don't dispute what
the
I was
text
saying.
messages.
I'm not disputing.
Okay,
that.
so
What I'm-
that was my only question. Now, hold on.
Mhm.
The way we're going to do this is I'm going to let Mr. Williams, if there's anything else you want to say that's new, you can say it. And then Mr. Richardson, after that, if there's anything lastly you want to say that's new, I'll let you say it as well. So, and that's not, I'm not favoring one of you over the other. Somebody has to go first, somebody has to go second. Mr. Williams, was there anything else you wanted me to know?
I'd like to just add that as far as him driving the vehicle, I'd asked that the vehicle be surrendered. I had hired a recovery team to come out and pick that up, and that that vehicle would be surrendered to that recovery team. This was not about him driving on the status of his license or not. It was about purely surrendering that vehicle back
Okay.
to the lease company.
Okay, thank you. Anything else?
No, sir.
Okay. And same thing, Mr. Richardson, is there anything additional that you want me to consider before I rule?
I have not seen a recovery team. Nobody ever came to my house except for the police. And they said that I stole, that you said I have a warrant that I stole the truck. And that's what I was trying to put that out right there.
Anything else?
All I ever wanted you to do was pay me my money. Give me my money. You can have your truck.
Okay.
Give me my money.
But you weren't gonna turn the truck back over until you got paid?
That was up in the air.
Well, but that's what you said.
Yeah, that's what I said.
Okay.
But if like the police said to me, listen, Mr. Richardson, give him the truck. Just take him to court. I know it's going to inconvenience you. Give him the truck.
Okay.
And that's when I spoke with Freedom Way, and Freedom Way was coming to get the truck. That's it.
Anything else?
No, that's it.
Okay. Thank you both. It's important that you both have your day in court. What happened to my video? Hold on. I want to ask pretrial services, do y'all show anything on Mr. Richardson? Is she with us?
Let's watch.
I have to go back. There it is. Miss Washington, are you there? Miss Washington? There you
Yes,
are.
I'm here.
Yeah,
Sorry.
good afternoon.
Good afternoon.
We're on number 11. Do you show anything for Ira Richardson?
No, not with that date of birth and information that was on the warrant application. No criminal
Okay.
history was found.
Okay, thank you. All right. So theft by conversion under OCGA 16-8-4 says a person commits the offense of theft by conversion when having lawfully obtained funds or other property of another, including but not limited to leased or rented personal property under an agreement or other known legal obligation to make a specified application of such funds or a specified disposition of such property, he knowingly converts the funds or property to his own use in violation of an agreement or legal obligation. And then the threshold on whether it's a misdemeanor theft by conversion or a felony is $1,500, the value of the property. So I'm doing two things here, and I think it's the first thing I will tell you is that I do find probable cause for felony theft by conversion. I also recognize, I'm not going to ask Mr. Richardson your age, but you're not a super young man and you have no criminal history whatsoever. And so that goes a long way in the second part of this, which is I could sign an arrest warrant and have you arrested in court today, but I'm not doing that. I'm not going to do that. What I'm going to do instead is bind the case over to Superior Court and then the DA's office, which ultimately makes the charging decision. You know, they can go forward with something or not. And if they do, they're the ones who have the burden of proof. Ultimately, when a case comes to court like this and a jury hears it, the DA would have to prove their case beyond a reasonable doubt. For today, I definitely think that there is probable cause for theft by conversion. You know, as of May 2nd, the text messages show, that's the one real documentation that I've got, you know, like you need to return the truck. And you said that you weren't, and you said why. Not later, not May 6th, but May 2nd. And so on the one hand, yes, there is probable cause, but on the other hand, I don't see any good reason to have anybody arrested today. Let me finish. It's going to ultimately be up to the DA's office what they want to do with the case. It's always their prerogative what they're going to do with the case. I'm not going to revisit my decision. Now, the only exception I'll make, and I mean, I'll give you just 5 seconds on this, is if there's something new that you thought, oh my gosh, I forgot to mention such and such, you know, it's kind of nerve-wracking in court sometimes. If that's the case, then I'll give you, you know, a brief moment to tell me something new. But if you disagree with that, that's okay. You know, I understood that either one of you were going to disagree with my decision. Is it something new?
No, but what I'm saying is.
Or do you have a question about what I've done?
Inactive. So there's no way I could have drove the truck to Georgia.
Right. We're not going to go back into the evidence.
Right.
Let me explain. I thought about some of that because this went down one way or the other. The question is, or the issue is, there is probable cause to suggest that, probable cause that you committed the offense of theft by conversion. This idea that you would have returned it, you said, no, I'm not returning the truck until I get my money. That's the basis of my decision. I know you disagree, and I respect that you don't agree. Where I am, you know, using my discretion is not having you arrested. I don't think there's any reason if you're, you know, let's say you're 60 years old. I don't know how old you are, 50, 60, 70 years old, whatever your age is, you have no criminal history. And so I have every reason to believe that with everything, the DA can get the case and then they can decide what they're going to do with it. And I'm leaving it at that. I'm not going to reconsider it. I've listened to everything very carefully, asked a lot of questions, given both of y'all latitude to share your side of the case. So that's what I'm going to do. I'm going to sign the bind over paperwork. And again, for both of you, it's going to be up to the DA's office when they receive it, what they choose to do. Okay. And so that's the ruling of the court. So you're both excused. I'm going to ask the marshal to say who can leave first. And if you're driving back to South Carolina, if you have a safe.
No, I have to get I bought a truck already. So.
Okay. I was going to say safe travels if you're traveling out of state. Be careful. And I found both of you believable. And there is probable cause for that offense. So I've ruled, and I believe, Mr. Young, that's our last case, correct? So we're in recess. I want to excuse pretrial services and also ask Mr. Tay to stop the recording. We're in recess. Thank you both.
Bye, Your Honor.
Thank you. Thank you. Have a good night.
All right, thank you.